Distinguished guests, good morning. We hope you're having a pleasant time so far. As we are still expecting a number of guests to arrive shortly, we will begin the session 8 in just a few moments. Thank you for your understanding. Ladies and gentlemen, the final day of the HCCH Asia Pacific Week Seoul 2025 will officially begin in about 5 minutes. We kindly ask everyone to begin taking their seats so that we may begin on time. May I also kindly ask the moderator and panelists for session 8 to take your respective seat on the stage. Thank you.
I'm going to start from here. So this is turned on actually.
Oh, sure.
All right.
Good morning, ladies and gentlemen. Welcome back to the final day of HCCH Asia Pacific Week Seoul 2025. I'm Gina Park, Deputy Director at the International Policy Division of the Ministry of Justice, and it is my distinct pleasure to serve as your MC once again. As always, simultaneous translation is accessible via the device on your table. Please tune into channel 1 for Korean and channel 2 for English. We have an exciting lineup of sessions today, covering private international law issues on 2 emerging areas, carbon markets and digital tokens. These topics reflect HCCH's continued dedication to addressing emerging global challenges. Let us now begin Session 8, Private International Law Issues on the Carbon Markets Project. Our distinguished moderator for this session is Dr. Geraldine Go Escolar, the Deputy Secretary General of the HCCH. She is currently responsible for the International Commercial, Digital, and Financial Law, aka Codified Division, making her exceptionally well-suited to lead this discussion. Before I yield the floor to the honorable moderator, may I kindly remind all participants to keep an eye on the clock for this session to run smoothly. Now, Dr. Escolar, the floor is yours.
Thank you very much, Ms. Park, and a very good morning to all of you. Thank you for joining us on the very third day of HCCH Asia Pacific Week 2025 here in vibrant Seoul. And for all of you online as well, thank you for joining us wherever you are in the world. I have the distinct pleasure today of moderating a panel of experts on an interesting area of the law, which is particularly exciting, not just to me, but I think to this particular region of the world as well. And we're really speaking about carbon markets. Now, before I turn the floor over to the panelists, what we thought was it might be interesting for me to walk through an introduction of this topic so that we could have, all of us, at least in this room and online, the same understanding of what we are talking about when we speak of carbon credits and carbon markets. Now, if I'm going to try and look at the slides now, what I will do is then give you an introduction into the HCCH's Carbon Markets Project. We have a newly established experts group, and this is really brand new. So you're really hearing it. One of the very first times we're saying this to a big audience, a brand new experts group that was mandated as of the first week of March this year. And they really study the private international law issues arising in the carbon markets. Now, before we go into what the group does, exactly what is this about? So you are all, I'm sure, very aware of the 1997 Kyoto Protocol to the United Nations Framework Convention on Climate Change, and it's fondly known as the UNFCCC. Now, this Kyoto Protocol introduced the concept of what we call the carbon credit. The objective, of course, is to create a mechanism by which the emission of greenhouse gases into the atmosphere could be reduced. The Paris Agreement, which is then attached as well to the entire framework, included carbon trading as a crucial component in the initiative to reduce carbon emissions in the international and domestic supply chains. In plain English, it allows financing, access to capital, access to finance, and a whole source of revenue for a just transition for every economy into the green and circular economies. Now, the sustainable growth of carbon credits globally is considered an essential element of international cooperation efforts to combat the challenges posed by climate change. Through the marketization of greenhouse gas, or that is carbon reduction and removal. Now, two types of carbon markets have emerged. The first is the state-developed emissions trading systems, ETS, and what's called the compliance carbon markets, CCMs, we like our acronyms, which implement obligations under international agreements. And the second is the evolution of what is called voluntary carbon markets through demand and investment by both state and non-state private actors. What is interesting is that both these markets are observed to now actually be colliding and merging, because it would not be possible for states to meet their compliance requirements and their obligations under the international framework without also having injections of carbon credits from the voluntary carbon markets. Why is this important? Now, these multi-stakeholders and divided kind of markets are now colliding, and these diverse actors provide significant market value and sustainable development opportunities. Carbon markets have seen investment in lots of projects providing significant environmental benefits. They also introduce innovative energy transition mechanisms, and they implement sustainable agricultural practices. These markets preserve biodiversity and have benefits for communities, including access to more energy-efficient technologies and employment opportunities, in particular to the most vulnerable communities of our global society today. So, we have this project and an experts group on carbon markets, and you would have heard this already yesterday. This is the progress of where the Codify projects are. It's a long name for the division, so we call it Codify. We have proposals, of course, of projects that will be of interest to study and monitor developments in relation to private international law. And along the way, a proposal is made to our governing body, the Council on General Affairs and Policy, we call it CGAP. And when CGAP thinks that the work is desirable, it's feasible, it's timely, then a proposal is put forward and mandated to form a group that would study this. And this, of course, is the experts group phase, which you see in that circle smack in the middle there. I've been told that there is a very nice laser pointer here, but because we don't have kittens in the room, I thought we wouldn't use that. But right there, that third circle, that's experts group, and that's where we are on several of the projects for the codified division, in particular for this case, the experts group on carbon markets. What is the mandate? At its March 2025 meeting, CGAP mandated the establishment of this experts group to study the private international law issues arising from carbon markets as described in the preliminary document that was submitted to it, with the initial focus of including an applicable law provision in one of our sister organizations' work programs. And our sister organization, the International Institute for the Unification of Private Law, UNIDOR, is working specifically on verified carbon credits. That's one slice of a very big project in relation to the carbon markets, and we're very pleased and proud to be able to contribute to that project. So that's the mandate, but what does this actually mean? Before this proposal was subjected to CGAP scrutiny and mandate, there was an exploratory phase that was held at the Permanent Bureau. The Technical Secretariat really looked at the private international law aspects of carbon markets in partnership with several subject matter experts. And this, of course, was reported. You see the reference there, so you can look at it online. We identified 5 volunteer pro bono subject matter experts. 3 of them are sitting on the stage right now, so I'll introduce them to you in a moment. But we had then a very interesting, very insightful report in relation to the private international law issues that arise in the carbon markets as a whole. Why is this important? The carbon markets is an emerging billion-dollar market that is expected to grow exponentially in the next few years. It is, however, a very complex market intertwined with lots and lots of different relationships, different actors, contracts, proprietary rights. We're going to look at all of this in this panel, but it is an extremely intricate web of different interconnecting relationships, all of which raise private international law issues. Now, we also worked in cooperation with our other sister organization, the United Nations Commission on International Trade Law, UNCITRAL. UNCITRAL and UNIDOR were working together on a study in relation to the legal nature, specifically, of verified carbon credits. And these verified carbon credits that our 2 sister organizations are looking at are specific to those issued by independent carbon standard setters. Now, carbon credits come in many different forms and different shapes. There are verified and non-verified ones, ex-ante ones which are issued before and traded before they're actually even produced. And so there are lots and lots of different setters, which I can't really go into in the time that I have, but the carbon setters also do verify when something is a carbon credit that is worthy of being traded on the market. Now, working with UNCITRAL and with UNIDOR, the HCCH submitted input to one section of this study, and as the issues of applicable law that apply specifically to verified carbon credits. This study was approved by the UNIDOR Governing Council in 2024 and is now being submitted to the Commission, which will discuss it and hopefully approve it next month in July of 2025 at UNCITRAL. Along the way, we also worked with UNIDOR in relation to their work on verified carbon credits, and their UNIDOR is looking at the characterization and the legal nature of these verified carbon credits. Now, what do we do? Our work is a much more holistic, wider look at the carbon markets. In private international law, we're a little less worried about what the carbon credit is, as opposed to what's being done with it and who's doing what with it. Why is that? There are considerations of public policy and overriding mandatory regulations, and it's important then to get policy views of the actors in the field. We don't create carbon markets simply to make rich people richer. We are creating carbon markets to ensure a just transition to energy efficiency and a green economy to contribute to sustainable development goals for every economy and every individual and business that contributes to that economy. It means that the private international law aspects of these carbon markets and the legal relationships within these markets are being studied at the HCCH, and of course, per our mandate, we exclude aspects of substantive law. We then look at the private international law issues that arise in the different phases of the carbon life cycle holistically, as each phase is interconnected with the other. We are also mandated by our governing body to consider the possible inclusion of an applicable law provision in UNIDROIT's work and their draft principles on verified carbon credits. And of course, this experts group is also mandated to study the feasibility and desirability of international cooperation mechanisms in this area. It is one of the largest experts groups we've ever had at the HCCH, and this is testament to the global impact of this particular field. 89 individual experts as of 2 days ago. We understand there's been another designation, so we've now crossed 90. From 23 HCCH members, that's 1/4 of our membership, and 9 relevant observer organizations which are involved in this experts group. What is the timeline? On the top, you see an arrow showing you the timeline at the HCCH and what we are doing there. Words are a little small, I apologize for that, but essentially we're somewhere on the 4th dot from the left on that circle, on the arrow that you see, the 4th circle, and that's the first working group meeting which just met just 2 months ago this year. And that was an initial focus on applicable law and to scope the project of what exactly we are doing. At the bottom, you see a line, which is what the timeline is at our sister organization, UNIDROIT. They look specifically to the principles that will delineate the legal nature of only verified carbon credits, and they intend to complete their work in 2026. Our work progresses beyond the verified carbon credits to the holistic carbon markets and will carry on past 2026 towards hopefully what will be a normative framework or at least guidance in this field in relation to private international law matters in the carbon markets. What is the scope? We issued an issues paper in version 1 containing some 70 different questions being discussed on jurisdiction, applicable law, the recognition and enforcement of decisions, and international cooperation mechanisms in the carbon markets. Some preliminary issues that we raise for analysis include the purpose of global frameworks and the existing international instruments, in particular Article 6 of the Paris Agreements and the Article 6 mechanisms that deal with carbon credits. We also looked at the entire life cycle of the carbon projects and subsidiarily the cycle of carbon credits in the primary and secondary markets within the entire project life cycle. We looked at different kinds of carbon projects, specifically those which are nature-based, so where there are forests that reduce carbon dioxide in the atmosphere, and those that are technology-based, so those which actually absorb or try to sequester carbon dioxide through technological means. And most importantly, we also look to safeguards to ensure that vulnerable communities, including indigenous peoples and minorities, are not discriminated in the framework in relation to global climate justice, and that all of this is done within the framework of international human rights law. So what are we looking at? Carbon markets as a whole, carbon credits, both compliance and voluntary, and not only verified carbon credits. Therefore, we also include ex ante, or what's called unverified credits. We acknowledge the convergence of the compliance and voluntary markets and include considerations, as I've said, of Article 6. We also look at carbon allowances or credits originating in compliance schemes which would be excluded from what we're doing because they're compliance entirely, but which also have an impact when we consider carbon markets as a whole. So, in particular, we'll look at the matter of revocations. What happens when a carbon credit has been issued and traded upon, and then something happens with the carbon project such that the credit has to be revoked? What rights do arise there? What kinds of obligations or liabilities would arise? We look at the private international law issues in relation to the rights of indigenous and local communities, including the rights of the use to the land and the environmental rights that accrue from such communities. We look at the role of registries that hold an entire register of these carbon credits, and we look at the role of intermediaries who trade and who basically make the markets function. We also looked at digitization and tokenization of carbon credits, and you will hear a little later today, this is the reason why carbon credits are excluded from the work of the other project on digital tokens. And in particular, we also consider public policy considerations and overriding mandatory rules, including, for example, issues of sovereignty over natural resources. We've tried to come up with a diagram which explains what we are doing. And here you see essentially the life cycle of a carbon credit. In the big circle there that it says project, I'm going to try and see if I can point here. There we go. There is a pre-project phase, and that includes essentially the proponents of the project that put forward a proposal saying, here I have 100 hectares of forest, it will reduce carbon dioxide by that many amounts, over that many tons, over that many years. And this is the pre-project phase where it's being proposed. If it progresses to the project phase, there is a life cycle here. The project is first validated, that's the first blue box that you see, and there might be ex ante issuance of carbon credits. Upon verification of the project, which is this box here, you can see ex post issuance of carbon credits here. There are possible situations where credits might be reversed, and that's where we also look at in terms of revocations, cancellations, and reversals of credits. And of course, there's a registration of the carbon project. Now, all of this could happen in one jurisdiction, and let's call that jurisdiction A. Upon ex post issuance, you can also see there might be some more revocations and cancellations, but there, when an issuance of a credit takes place, it's usually registered. And in most cases, the registry is in a different jurisdiction than the jurisdiction of the project itself. That's jurisdiction B, the registry. Here is a different life cycle, and that's the life cycle of the carbon credit. It is one slice of the entire life cycle of the project. And here, in the registration phase, you can see that there's the primary market with the first entitlement that might go to multiple jurisdictions. And then, in that case, once the carbon credit is used, it will be retired, and that will be in the jurisdiction B, which is that of the registry as well. All of you, especially those of you who have traveled here, would have, when you bought your tickets, got to a stage in the booking process that said, would you like to offset your carbon emissions for your travel? This is what we're speaking of, essentially. And when you offset it and you pay some money towards offsetting that carbon footprint, the credit is then retired to ensure that there is no double counting, so that 1 ton of carbon dioxide that is reduced is not counted twice or 3 times over, and there is a proper accounting of the carbon system. There are also dispositions you can see after the second entitlement, and that's where we're talking about the secondary market. UNIDROIT's project on the verified carbon credit focuses on this box here in relation to the secondary market, the entitlements and dispositions of the credits there. And what the HCCH's project focuses on is the entire project life cycle. So it's quite a different focus there, but it's quite important to understand exactly the work that we're doing. I won't go through this, but there is a map of private international law questions that we are asking at the PB to our experts group per stage and per moment in the life cycle, ranging from the authorities of which state would have jurisdiction to the applicable law for each of the transactions in this life cycle, the questions of whether party autonomy would apply, are there limitations to party autonomy, how would that interact with market regulations, and as well as the rights and obligations in relation to this. What's the next steps? This is the program from 2025 to 2026. This project moves at a more accelerated rate than most of our other projects, and this is to accommodate the developments in the field and also the developments at our sister organizations. So we've just had the first meeting in May, and the first working meeting agreed to intersessional work, which the Permanent Bureau is now putting together. The experts group will meet once more in October and again in December before reporting to our Council on General Affairs and Policy in March of 2026. And that then concludes the introduction to the carbon projects market, carbon markets project, forgive me. And now I will turn you over to the panelists who will walk you through the questions that we're asking in relation to the private international law issues arising in this market. Now, our first speaker is Ms. Amy Held. And Ms. Held is one of the 5 pro bono experts that we have that contributed to the project last year in the exploratory phase. Ms. Held was called to the Bar of England and Wales in 2019 and is an affiliate academic in common law at the Department of European Comparative and International Law at the University of Vienna. She has an extensive biography, which I will not read to you, but I would like to turn the floor then over to Ms. Amy Held. Thank you very much.
Okay, thank you so much for that kind introduction and for the invitation to speak here today. It's obviously a great privilege, but also a great pleasure, especially given the work I've been involved with at the Hague Conference over the past year on its carbon markets work. I have been very conscious in my planning for this presentation that the carbon markets is a very intimidating emerging topic. I think I speak for all of our co-panelists that it's a learning experience for all of us. And so what I'm proposing to do today is to break down the carbon markets into more discrete units that we, specifically as private international lawyers, can digest a little bit better. And hopefully this will set up the discussion for the specific PIL issues that my co-panelists will address. So my presentation in PIL terms will go to characterization, and there are two main parts to my presentation. First, I'll set out and introduce the main parties that are involved in these markets and their particular relationships. And then, if there's time, I will look at a few problematic relationships that we may need to deal with in the scope of our project. So from that, my presentation looks specifically at the voluntary markets. And these are voluntary in the sense that actors in this market have no regulatory obligations to reduce emissions under the UNFCCC. There may, of course, be other incentives, such as reputational incentives to make green claims, but ultimately these are driven by private interests rather than compliance with public law or regulatory requirements. And so, the backbone of the voluntary markets are private carbon mitigation projects that generate voluntary emissions reductions. Now, these reductions go by a variety of names, but for today, we can think of them as carbon credits, which represent or relate to the reduction of 1 metric ton of carbon dioxide from the atmosphere. These are some of the projects that are involved with carbon mitigation schemes. There are a wide range of ways in which you can remove 1 metric ton of CO2 from the atmosphere. Now, this sample of projects I've taken from South Pole, which is a global climate solutions leader, and these are some of the projects it is involved with local partners around the world. Now, I won't go through these in depth, but you can see that there are lots of different ways in which the projects work. We might be planting trees in Colombia, or we might be preventing trees from being cut down in Uganda. We could be capturing methane gas in Thailand, or helping cows with their digestion in Switzerland. For our purposes of private international law, it's less about how the project works, but the people who are involved in the projects. So let's meet some of the main players. And here they are. Now, let me say at the outset, don't worry about trying to read any of this. Part of the reason why the voluntary carbon markets is so challenging, at least from a pure private international law perspective, is because it encompasses such a wide range of intertwined private interests. And I think it's really here that we're most likely to get overwhelmed in trying to understand what the carbon markets are. So I think it's quite helpful to remind ourselves that the first step in any PIL analysis is always going to be characterization. What particular private law right, obligation, and/or relationship are we actually looking at and which calls for a PIL analysis? And to try and help navigate this, I've set out all of these private parties and their relationships in a diagram. Now, I'm mindful that this is just as overwhelming as the list on the previous slide, but my plan is to break this down into some discrete chunks. And the first step in breaking this down is to note the registry, which is there in the middle, in bold. The registry is the central point in the voluntary markets. All the parties can be thought of as either pre-registry, I beg your pardon, pre-registry. Anyone to the left of the registry, these are known as your upstream parties. And anything right to the registry are your downstream parties. Okay, so we're going to start upstream. There are three main parties here that we need to worry about. Again, don't worry about reading this slide. These three parties play different roles in the project itself, but in legal terms, the core point to note is that all three of these parties make enforceable legal representations that a particular carbon project works, and it's successful in reducing greenhouse gas emissions. So let's get started in what they're actually doing. Your project proponents are the persons with overall control and responsibility for the project, and in practice there tends to be two of them working together. We saw a few slides back, South Pole was a global climate solutions leader, and they have global expertise in the carbon market, project management and design, and they have the kind of technical expertise necessary to implement these kinds of projects. And they might be approached by local parties who want to run a project in their local area, but they don't have the expertise to design and run the project. So they will partner up, and there will, of course, be a contract between them. At this point of the project, it might be being financed by a startup investor or a unicorn investor who are willing to take this kind of risk in a project, which is quite considerable. These projects tend to run for 25 to 50 years on average, and a lot can go wrong. So these upstream investors supply the initial finance required, and in return they receive an ex-ante credit, which, as the Madam Deputy Secretary General explained, is a credit that doesn't exist yet, but one that's going to be generated in due course by the project. And so when enough money is in place, the local project proponent will start to apply for the kinds of regulatory permissions it might need to run a project. It will ensure it complies with all of the local laws that are in place where the project is going to be carried out. And so finally, when the project is more or less ready to go, the project proponents will apply for the project to be audited by the validators and verifiers. And they basically review all of the project documents to check that the project works. And now, if the validators and verifiers are satisfied that the project complies with the relevant standard, then all three parties will make legal representations to the registry that the project works. And so when the registry is satisfied that the documentation is all in order, it will issue the carbon credit into the project proponent's account. And this is the core moment when the carbon credit comes into existence. And once it's been issued, it can then be traded amongst the account holders of the registries. Okay, so the carbon registries play a crucial role in the voluntary carbon markets. Here I've got here the 6 largest international carbon registries. By far and large, Vera has the largest market share. This is a non-profit organization incorporated under the laws of DC. Each of them have slightly different terms and conditions. My presentation is based on the Vera model, given its dominant position. But irrespective of the specific terms and conditions it offers, all registries play the critical role of issuing the carbon credit and facilitating its trading amongst account holders. And what's really important for us as private international lawyers is that there are, of course, contractual relationships between the registry and each of its account holders. Now, this is really important for several key reasons, but the most important one is that the registry's terms and conditions will address the legal nature of a carbon credit that it issues. You know, commercial parties will often say they trade in carbon, it's a thing that appears on their accounting records. But for us, this is not really precise enough. We have to ask ourselves what is actually happening in legal terms when credits are moving between accounts with the registries. And given that the accounts and the credits themselves are creatures of the registry's terms and conditions, that's our starting point. For Vera, we have to take a few steps back and to remember that before the credit was issued, the project proponents, the validator, and the verifier all made legal representations to Vera that the project works. And those representations are enforceable by Vera under a deed governed by English law. And then it was only when Vera was satisfied with these documents that it issued the credit into the project proponent's account, which could then be traded to any one of the other account holders. What actually happens when the carbon credit is transferred to another account is that the person who receives the credit is assigned the representations made to Vera, such that they are now the person entitled to sue on the representations made that the project works. And in this, Vera disclaims in that deed any and all responsibility for the project or the presentations. Now, this is a unique feature of the Vera model. Not all registries confer direct rights of action against the validators and the project proponents. That's a mere difference of detail. The core point to note is that the registry will always be our central point in the markets. So that's pretty much primary issuance and primary trading. The next group of parties we need to consider are our downstream parties and transactions, and these are the investors and traders who ultimately are financing the project. Now, they have a wide range of commercial incentives for doing so. Some of them will eventually retire the credit to make a green claim, to say basically, I'm a responsible company, so you should buy our products. Some investors will actually treat the credit purely as an investment. But the core distinction for us is not so much why they are investing, but whether they hold accounts with the registry or not. So here are your account holders who can trade carbon credits between them within the registry system itself. But they can also enter into transactions with parties who are not account holders. And the first non-account holder to mention is actually an upstream party. It's our unicorn investor who's financing the project from the outset. Now, in practice, what they will tend to do is they seek further financing from a corporate investor because there's no way that a startup investor can fund the whole project themselves. So what they do is that they give the ex-ante credit they received to a corporate investor like Microsoft or Shell, who will find the funds then to contribute to the project at the outset, which is why in the diagram, our project proponent has sent the carbon credit once it's been issued to the corporate account holder once it's been issued. Now, the corporate account holder might have entered into other transactions using the credit. It might have entered into an ordinary corporate debt arrangement using the carbon credit as collateral. You also might have external investors who have invested indirectly in a carbon credit through a green bond, for example, linked with a carbon credit or a project. And then, of course, there are always your derivatives markets. So that's the basic overview of the private interests engaged. I hope it's gone some way to break down some of the carbon markets into discrete private law rights that we're a bit more comfortable dealing with. I do have some slides on some things that can go wrong. Okay. I'll just whiz through some of them. So there are three main things that could potentially go wrong. So what happens actually if the project doesn't work and the project carbon credit has to be cancelled? Now, in the first instance, under the Vera model, the account holder whose credit has been cancelled has direct claims that they can make against the project proponents and validators. A more interesting question is whether the account holder also have claims against the local community based on the local project proponent's legal rights in relation to the project. Okay, the second thing that could go wrong, what if the project proponent has failed to comply with the local law regulations such that the local communities might seek redress against them? Here, the question is a little bit more difficult. We're not particularly sure what kind of claim they might have against the project proponents, and that's, of course, a matter of the relevant applicable law. Another question is whether they have any rights to the carbon credit itself. And the third basic question is what if investors disagree as to who is entitled to the carbon credits and are all making claims to the same one? And here we have to remember that the account holders will have contractual relationships with the registries, which actually confirms that what they're fighting about is the legal right to sue, might have a claim against the local community, which in turn might have a claim on the carbon credit itself. So now this is starting to look very, very complicated, and it is the case that it is. So basically, I want to wrap up and conclude by saying that basically, I think it's very important not to get overwhelmed with what the carbon markets are as a whole, but to focus always as PIL scholars on the particular legal rights that are engaged. So I have put my thoughts out there, but I think I'll leave the actual substantive discussion to my co-panelists. Thank you very much.
Thank you very much, Ms. Amy Hill, for that wonderful presentation, breaking down what I think I understand it better now, at least myself as well. So thank you for that brilliant presentation. Ms. Held also sits for the United Kingdom on the experts group for carbon markets. Now we turn to the issue relating to jurisdiction and jurisdictional grounds, and it gives me great pleasure to welcome to the podium Professor Pietro Francina, sitting for the European Union, European Commission, on the experts group on carbon markets as well. Pietro was also with us as one of the subject matter experts last year during the exploratory phase. He is full professor of private international law at the Catholic University of the Sacred Heart in Milan in Italy, and has been so since 2020. And at the same time, at the same university, he is director of the Institute of International Studies. Now, he's been professor of public and private international law at the University of Ferrara of Italy from 2010 to 2020, and has also an extremely extensive CV. But we're delighted to have Pietro here. And so, Pietro, you have the floor. Thank you very much. Will you join me in welcoming him, please?
Thank you. Thank you very much. And allow me first to reiterate my gratitude to the co-hosts and the organizers of this conference for having me. And let me also clarify that although I sit in the expert group on carbon markets on behalf of the European Commission, I will be speaking in my personal capacity, and the views I will be expressing are just my own, and I do not intend to represent the views of the Commission today. The task I have been assigned is basically to provide some thoughts on the relevance of jurisdiction to the governance of carbon markets. I think that from what we heard from Amy, from a brilliant presentation, some of the thoughts that I will be expressing are already clear. But let me focus on those issues, and let me try to remind some very basic things to start with. Private international law, as we all know, deals with a range of issues, applicable law, of course, but also jurisdiction, the recognition and enforcement of judgments, and interjurisdictional cooperation, as I used to call it, so exchanges, dialogue, exchange of information, for example, and cooperation generally, and mutual assistance between authorities of different states. Now, all of these issues are relevant to the analysis of a cross-border case. And as all practitioners know, it is hardly advisable to address a cross-border case without considering all of these issues in a coordinated fashion. If one issue, if one aspect is left out of the picture, the risk is that we reach unreliable results in practice. And there is a obvious, I would say, but still worth mentioning, connection between applicable law and jurisdiction. And let me explain why, in essence, or at least provide some hints on this. Now, conflict of laws rules, the purpose of which is to determine the applicable law, vary in principle from one state to another. This means that rules in the various states might understand the same situation differently, because characterization is, in principle, guided by the lex fori, and might regulate the same situation differently, that is, based on different connecting factors. This means that, in the end, which substantive rules apply in a given case depends first on jurisdiction. But even where conflicts of laws rules are harmonized, jurisdiction matters. And it's so for the reasons that have already been expressed by Jerry to some extent and by Amy indirectly. That is that overriding mandatory provisions and public policy varies from one state to another. And in order to determine what the impact of overriding mandatory provisions and public policy might be on the substantive regulation of a situation, you need to know first which courts have jurisdiction. Why does jurisdiction matter in a field like carbon markets? Now, let me remind first that jurisdiction is about a state's power to adjudicate through its courts disputes, a state's power to shape substantive relationship through the operation of both its courts and its authorities generally. But jurisdiction is also responsibility. And let me explain this, because I believe, at least it's my personal take on this, of crucial importance in this particular field. Through its rules on jurisdiction, a state asserts its willingness to exercise some form of control over a social or economic reality by instructing the courts to entertain a case or a class of cases. The state in question makes sure that the interests underlying the case are managed in a way that is consonant with its own policies. It is in this sense that jurisdiction has to do with control. And state generally express this willingness of exerting some control on a certain class of situation because they consider they have a responsibility to do so. A responsibility towards the community they govern, for example, or, as in our case, towards the international community. Now, when it comes to carbon markets, we're not talking about exchanges that are just like exchanges of any other goods or tradable entity. No, this is a special kind of market. And as Jerry has brilliantly explained in her introduction, this market is very much one of the ways that has been devised to ensure that climate policies may be implemented. This means that the interests, the stakes are very high and concern the global community, concern our own future. To put it normatively, what is at stake with carbon markets is international obligations of states as they arise from the Paris Agreement, among others. But it's also a whole range of obligations that states have undertaken based on their constitution, sometimes based on international law. Obligations in the field of environmental law, obligations that relate to the rights of local communities and indigenous population. Exerting a control on carbon markets is a way, so to say, to live up to the expectations that arise when a state, or states generally, are faced with these kind of obligations. That is peculiar of carbon markets and generally of areas where private law and private international law meet global concerns and international obligations. Now, it is not my task here, and I wouldn't be able to discharge that task, to suggest some possible contents of jurisdictional rules that might be applied in this area. It is too early, of course, at this stage of the carbon markets project at the HCCH to focus on possible contents. What I would like to do, rather, is to remind all of us that there are several issues relating to jurisdiction that are worth considering. There is, of course, the issue of allocation of jurisdiction, and when we think of jurisdictional rules, we think basically of rules that confer jurisdiction on the courts of a certain state, and by that make sure that other states refrain from asserting their jurisdiction. Allocation is, of course, an issue and a crucial issue, but there is more. And there is cooperation. Jurisdiction can be seen from two angles, and this is, let me remind you, very much in the toolbox of the HCCH to be able to deal both with the allocation of jurisdiction and with cooperation between states in the exercise of jurisdiction. And as we heard, the very jurisdiction project that is going on at the HCCH is about cooperation in the exercise of jurisdiction. Well, I think both dimensions of the problem of jurisdiction, the allocation and the cooperation, are relevant in an area such as the governance of carbon markets, precisely because, as it has been recalled, different interests are at stake and different states may legitimately assert an interest in dealing with those policies, expressing their views and exercising their control. So it's not just which courts have jurisdiction, which is worth considering in relation to carbon markets, but also how the various states might be able to cooperate in the exercise of jurisdiction. It has been said that a holistic approach to carbon markets is advisable. But holistic is a nice word and can be used in different ways. First, it can be used to suggest, as it has been recalled, that carbon markets are complex, that the life cycle of carbon credits is long and complex, and all aspects should be considered in a unitary fashion. But I understand the term holistic in a slightly different way here. Holistic meaning that all issues of private international law should be considered. Applicable law, jurisdiction, recognition, cooperation between authorities. This is not new. There are stories of success, both in the European Union, for example, in the EU private international law, but also in the HCCH history where different multilateral instruments, successful ones, very successful ones, are successful because they deal holistically with the various issues that relate to private international law. One example is the 1996 Child Protection Convention, which includes rules on jurisdiction, applicable law, the recognition and enforcement of judgments or measures of protection, and the cooperation between authorities through central authorities as may be appropriate. Now, holistic approach of this kind is, I suppose, relevant and useful in all areas where several states have common concerns, the best interest of the child in the case of the 1996 Convention, but consider that each of them should enjoy some degree of autonomy and have individual responsibilities in determining how those concerns should be addressed. And when this combination exists, common concerns, but an awareness that each state has its own role to play, there is room for cooperation. Cooperation based on those common concerns, but also in a manner that is respectful of the autonomy of each state. And the state's policies in the field of climate change, including as regards carbon markets and carbon credits, appear to fit into this description. There are different responsibilities and differentiated responsibilities in the international law of climate, and climate is, of course, a global concern, so all conditions are met to consider that a climate-friendly private international law is necessarily, by nature, by vocation, a private international law that holistically addresses all aspects of private international law: applicable law, recognition and enforcement of judgments, cooperation between authorities, and indeed, as I said, jurisdiction. Thank you.
Thank you very much, Professor Pietro Francina. A wonderful holistic look at jurisdiction and its ties to public policy and to climate justice as a whole. So thank you very much. We'll leave some room for discussion there. But we have then our third panelist up, and that's Professor Fabrizio Pascual Pulido. And he is Associate Professor, tenured one, of Private International Law, Comparative Law and New Technologies at the Law School of the Federal University of Minas Gerais in Brazil. He's also the Brazilian delegate on the experts group for carbon markets, and also one of the pro bono subject matter experts that contributed to our work last year. He is a permanent faculty member of the university's graduate program in law, which he coordinated from 2015 to 2018, and also teaches in the graduate program in technological innovation. Professor Pulido, you have the floor. Thank you for joining us. Will you welcome him as well? Thank you.
Well, good morning, everybody. I would like, first of all, to express my deep gratitude to the organizers, to the South Korean government, the Ministry of Justice, and also our organization, HCCH, from Mr. Benasconi and Mrs. Geraldine Co-Escolar, for their very inclusive approach and generosity to bring us here as well. And I'm happy to be here, not only because it's my first time in South Korea, but also by the occasion of the celebration of 65 years of diplomatic relations between South Korea and Brazil, which is a very important figure, particularly due to the beauty of the relations that were built between our countries. So thank you so much, and I would risk myself to say, Gamsa Hamnida. So my first intervention here is to propose a topic which was chosen by the organization, and I was very glad to share some of comments related to my work as an expert, but now, of course, I'm talking about on my personal capacity as a scholar, and also expert in private international law, and also a comparative legal traveler, I would say, that's about to check how private international law and emerging issues such as climate change, and we are talking about here a very important aspect related to the commitments in the multilateral obligations by states in relation to very important international environmental treaties, and this relationship between private international law and further international legal fields is a very necessary one. So I would like to remark that my position also is to defend such interactive and consistent approach in relation to which private international law will deal with such aspects. And so I go for a very systematic presentation. I hope not to get you bored about it and tired about listening to me, but my colleagues, Professor Franzina and Mrs. Emiheld, already brilliantly explained several parts of the whole categories and systematic approaches to some issues, from conceptual but also jurisdictional issues that are very important at this stage of the project as we are discussing. But my idea is also to focus on a particular cluster involving some private international law aspects related to carbon markets, specifically the verified carbon credits land-based projects. It's a very technical category of those transactions that were already explained by Ms. Held in her presentation. I'm glad that she made a very systematic presentation on the whole topic, so I would like to recall to those distinctions, but also to come across to some particular concerns I have as PIL scholar, in particular to the intersections between private international law and land-based projects. In those projects concern verified carbon credits. In Global South, PIL dimensions, which are very important, particularly with regards to the indigenous rights and local communities' rights that are mainly involved in such projects. And that's why, even for a private international scholar, it's not to be underscored the importance of those interactions and also, I would say, systematic dialogues with further international legal regimes, in this case also international environmental law, constitutional law, and also, what is very important in this case, the intersection with some human rights or fundamental rights of those local communities which are involved. And basically in private international law, we can deal with two different, I would say, formats. The first is related to public policy considerations and overriding mandatory rules that could put aside applicable law or even to refuse a recognition enforcement of some foreign judgments involving such topics. This is a typical way. The other is the particular tension between private international law and human rights. In some cases, we have to admit here, we have also some legal regimes such as international labor obligations arising from international labor conventions that would have some overlapping effects in relation to private international law instruments. So that's why it's important to understand. Of course, the first part of this presentation is really a focus on the main traditional clusters or sectoral issues of private international law, ranging from applicable law, jurisdiction, recognition, enforcement, and international cooperation mechanisms involved in markets, in carbon markets, and also specifically in VCC projects, land-based VCC projects. And when you're talking about applicable law, especially in those cross-border contractual property, tortious matters related or arising in relation to land-based VCC projects, we will be really looking at very important responses and solutions that private international law can offer in relation to those technical issues related to applicable governing law to those transactions. The second is, of course, covered brilliantly by my colleague, Professor Pietro Franzina, in relation to jurisdiction and the importance of discussing jurisdiction in those issues, particularly land-based VCC projects, is that because we touch very sensitive areas, particularly in several member states of the HCCH or countries, in which the civil procedural rules or private international law codes, national codes, touch aspects of exclusive jurisdiction involved in the discussion of the land, real and also in rem rights, which is generally one of the most also sensitive areas for purpose of recognition and enforcement of foreign judgments. As we testified during the very fascinating negotiations of the Judgments Convention in relation to Article 6 of the Convention, which gives the grounds for refusal of recognition and enforcement in those cases where the filter, the jurisdictional filter is not observed by the country of origin, and so and therefore the foreign judgment is to be refused in the state of recognition. So this is something very unique because we are looking to the existing instruments, private international law, and how they can potentially interact with very technical issues from the point of view of the states where, for example, those land projects are based, where the land is used, explored, and, for example, a forest is reforested, and so on and so forth. In the public policy mandatory rules that can be also listed in those, I would say, exploratory phase, apart from constitutional rules and indigenous rights, what would be the main variety mandatory rules and public policy implications coming from those projects? And they will probably reflect or will result in those particular concerns in relation to public policy considerations and mandatory rules. I will talk about a little bit later in this presentation about the free informed consent, which is a requirement to be observed by the project developers in those cases where the land which is subject of the project is exploited locally. The recognition and enforcement, also to what extent judgments issued by the state of origin can be recognized and enforced by domestic courts of the country where land rights are constitutionally protected. And I'm talking about this particularly specification because in many jurisdictions, especially from the global south, indigenous rights and also local communities' rights are protected under constitution law. And so there will be a clash between the implementation and development of those projects, which are by chance verified and registered in a different jurisdiction and in a particular with regard to a land which exploited or used in a different country and therefore subject to a different jurisdiction. So these relationships between those jurisdictions from one side and the connection between the land use and the implementation and development of a project, a land-based project, is relevant for private international law purposes. That's something that I would like to remark. And some of the conceptual normative issues that are related to land-based projects for private international lawyers and comparative lawyers, definitions are very important, categories. So that's not because we are obsessed about categories or normative issues, but because they will be at a certain instance of a legislative project as the one which is going on under the HCCH to be included in a potential instrument, which can be a treaty or principles from soft law instruments and so on. So categories are very important. And the definitions coming from carbon credit land-based project usually comes from private, especially private instruments. For example, terms of use of the verifying authorities or the registers. And this is something that is somehow a creation from the practice of the market. So what we are doing in the end of the day is capturing and observing those creations coming from the private market, especially the market involving voluntary carbon credits, which is the case of the VCCs. So there are many activities involved, for example, in a land use in those projects, ranging from afforestation, avoided deforestation, particularly under the acronym RED, reducing emissions from deforestation and forest degradation, which recalls the enforcement, concrete enforcement actually, of Article 5.1 and 6 of Paris Agreement. So there is an umbrella under international environmental law, which private international law related issues will be attached at some point. And it's not only a matter of substantive law applicable to those projects and also to the land which is object or subject to the project itself. We are talking about sustainable management of forests, soil carbon sequestration, agroforestry, sustainable land management, and wetland refloration. So as a PLL scholar and comparative legal scholar, I was somehow obliged, forced to understand better what would be behind this scenario. And Mrs. Held had made a very important point in touching the actors, the subjects, the parties involved in those projects. And this is a very important aspect for private international law. We are not only focusing on the relationships or cross-border transactions, but rather on the actors, subjects involved in those transactions and how they could be related to those particular aspects. What a VCC land project indeed is a land-based carbon offset initiative. They generate verified carbon credits, which can be further transactions, sold, transferred to entities, companies, governments, individuals. But in the end of the day, they are concentrated in the hands of few actors or subjects, which are located in few jurisdictions, for example, United Kingdom, United States, Switzerland, and they refer to the management or the use of lands that can be located elsewhere. So there is a concrete technical issue to be understood from the point of view of private international law. It's not as simple, but it's a very challenging one. The main features of those VCC land-based projects comprise the physical land and natural resources that usually are subject of those projects. Those projects are subject to local environment, social and legal regulations, including indigenous rights, local communities' consent, which is a requirement under international law, general international law. In the act of verification, which involves monitoring carbon stocks over time, using scientific and technical methods, which is something, a very unique purpose. I took this very important indicator showing that the majority of carbon credits issued worldwide originate from forest and land use projects, followed by renewable energy projects. There is a very important figure that estimates that those projects are developed also in global South countries, Latin America, Asia, and Africa. So that's why it's important to understand these issues. And coming from some I would say findings from scientific research literature on this topic, a very recent one, we can understand how Latin American markets or carbon credit markets are increasing and why there are so many important countries in the region that offers different potential space for expansion of those land-based VCC projects. And that's why it's a unique interest topic for countries from Global South, in particularly here, countries that have a large territory, a vast territory with natural resources and lands. And of course, there are some key issues and concerns regarding the measurement report verification and regulation between those countries in relation to those projects involving verified carbon credits, which are somehow attached to the use of lands in those countries. That's just an overview, and this presentation is also available to all participants for a deep analysis. And systemic challenges to VCC land-based projects in Latin America that I could at least list, they are related to three particular issues. The first is the lack of capacity building from sectoral participants. That's why stakeholder participation in all kinds of negotiations are very important. The way how those indigenous people and local communities are disproportionately vulnerable to actual benefit sharing in carbon credits projects, because some national and domestic legislation will require those products to make it a proper benefit sharing in relation to the use of that lands with the local communities and indigenous people. And also how the way carbon markets and RED initiatives may be not achieving the desired environmental, social, and economic goals, which is an issue that could be covered by public international law, in particularly the Sustainable Development Goals, but they are also important from point of view of private international law. As the private international lawyer, a specialist cannot simply overstate the importance of those particular issues. And final, just to go to the end of this presentation, are the prospective POL scenarios in relation to VCC land-based projects. First is to get this outcome that the between the interplay between private international law and VCC land-based projects is not a marginal debate. They raise complex legal issues due to the link between carbon rights, which are generated, the project development and management, and the land and property rights. So from the standpoint of proprietary rights, and also important for private international law, the legal status of the land refer to full set of legal attributes, rights, interests, and restrictions, potentially restrictions that can be applied to that particular real right, and of course the land which is subject to use and exploitation. I just quote some of the parts, excerpts of the wonderful material, also accumulated by the work of the experts groups in the report that was submitted to CIGAP this year, in which the list of the potential projects involving carbon credits under consideration of appeal policy are expressly listed, and number 6 is forestry and land use. So there is a clustery issue, a sectoral issue, which is very important to this thing. And of course, as PIL scholar, it's important, and a specialist, it's important to understand the ancillary PIL issues and those VCC land-based projects, which range from cross-border litigation involving contractual obligations related to the transfer of VCCs, but also to the implementation of the project, particularly where there were, for example, breach of obligations arising from those projects in relation to the unilateral declarations made by the accountant holders. So those are the main potential litigation issues, or contentious property issues raised before a foreign court or arbitral tribunal in cross-border dispute involving a VCC land-based project, which is something very important at this stage. And of course, the way how the information and prior consent from indigenous and local communities are observed in those particular projects, since this FPIC can be deemed a public policy or even overriding mandatory rule in some jurisdictions. So this is a very unique aspect in relation to each of those issues. And to summarize, which I leave as a key takeaway for everybody in this presentation, after this presentation, is this clustering and PIL component in relevance of issues that can be put inside the intersections with land-based projects. And I would just make here a red flag in some of those I understood they would be more sensitive from the point of view, for the standpoint of policy in private international law, which deals with property disputes in VCC land projects, and also the requirement of free and prior informed consent that could be understood as a public policy overriding mandatory rules. And of course, this is not an end debate, it's just to understand how private international law in carbon markets has no one-fits-all solution. They will lead to a set of public policy considerations, particularly what is related to the PIL norm setting approaches to be discussed within the framework of IOS, HCCH, UNIDROIT, UNCITRAL, and of course, under my public and private international law perspective, those issues will be related and they shall be understood under the lens of an interactive systemic approach vis-a-vis the overlapping regimes, international law, environmental law, constitutional, the indigenous and local communities' rights and human rights. There is no single format adequate to respond to all those demands. So thank you so much for your patience, and I'm glad to respond to any questions that you have after.
Thank you very much, Professor Pulido, for that very interesting presentation. More than 50% of carbon credits are issued from forestry and land-based projects, and so it's really important to understand why this particular field is something we want to focus on. Now, for our last speaker of this panel, we have Professor Changmin Chun from Seoul National University of Science and Technology, the Department of GTM. Professor Chun read his doctoral degree at the University of Hamburg Faculty of Law, and had 2 master's degrees from McGill University in Canada and the University of Minnesota in the United States. It's my great pleasure, and I ask you to welcome him as well together with me as he speaks about the carbon credits market in Korean private international law. Professor Chun, you have the floor.
Good morning. It's a great honor to be here and to share a brief introduction to legal issues related to carbon credit markets in Korea. And also I'd like to express my sincere gratitude to all the organizers of these fantastic events for inviting me as panelist. The topic of session 8, as you already learned, is relatively unfamiliar. It's known only to limited number of specialists. Needless to say, the private international law aspects are even less explored. In this regard, I'm certain that today's presentation by Dr. Escola and other panelists was excellent opportunity to better understand the private international law implication of carbon markets. With that in mind, my remarks will proceed in 2 parts. My presentation is really short, don't worry about that. So the first one is substantive law aspects, and the second is private international law aspects of credit market. First, let me begin with substantive law aspects. Although I mentioned substantive law aspects, more precisely speaking, there will be regulatory aspects. Under the Korean Capital Markets Act, carbon emission allowances are not classified as financial instruments. They are legally treated as commodities. Therefore, they are outside the scope of Korean financial regulation. The Korean Capital Markets Act classifies financial instruments into 2 broad categories: securities and derivatives. Securities themselves are divided into 6 types. The key test whether certain instruments are financial instruments is the intention of profit gain. As carbon allowances or credits are not issued for profit, they are not financial instruments. This is why even financial law scholars are not familiar with carbon allowances markets. Interestingly, voluntary or verified carbon credits, VCCs, which are issued by private sectors and traded for profit, may be regarded as investment contracts, one of the type of securities under the Korean Capital Market Act, depending on their structure. However, I personally think that it would be rare for verified carbon credits to be classified as securities under current legal framework in Korea. In terms of trading infrastructure, Korea operates an emission allowance exchange run by the Korea Exchange in accordance with Emission Allowances Trading Act. This is a special law for emission trading. This trading platform allows only officially allotted emission allowances to be traded. Carbon credits issued by private sectors is not allowed to be traded on this exchange. In this regard, the Korean carbon market is essentially a compliance credits market rather than a voluntary one. However, it is possible for certain types of credits to be converted into official emission allowances if they are verified by competent official authority as provided under Article 29 of Emission Allowance Trading Act. That was for accommodating Article 6 of the Paris Agreement. And I've checked the practice on this matter, and I found that most privately issued and verified carbon credits are not eligible for such conversion offset, as long as the practice are initiated by public sectors such as the HCCH also. So therefore, however, many Korean conglomerates or airlines companies participating in carbon credits markets abroad because they want to meet the RE 100 standard. So, but in Korea still itself here in Korea, that kind of credit markets are not formed fully. Now move to private international law aspects of the Korean carbon market. The Korean private international law, KPILA, was modernized through 2 times of amendments in 2001 and 2022. The 2001 amendment focused on choice of law rules with considerable influence from European private international law. The second revision in 2022 sought to modernize specific jurisdiction rules, again inspired by European law and international discussions such as Hague Conference 2005 Choice of Court Convention and 2019 Judgment Convention. Under Korea private international law for proprietary issues, the lex situs rule applies strictly. No party autonomy is allowed at all. By contrast, for contractual issues, the KPILA provides broad party autonomy. There's also general escape clause under Article 21, which enables the court to apply the law of the country with the closest connection to the issue concerned. Now, when it comes to carbon credits or allowances, proprietary issues become quite complex because these instruments cannot be treated as things under the KPILA. According to the current Korean law, carbon credit could be categorized as nominative claims. However, I do not think that carbon credits could be a nominative claim because the nature of carbon credits is kind of certification, and usually carbon credit holders have no claim vis-a-vis issuers. Therefore, probably carbon credits can be characterized as mere intangible assets or even data. This leads to another question. Should we then treat carbon credits like general digital tokens for the purpose of private international law analysis? If so, should we determine the private international aspects based on the location of intermediary or the place of registrar? Or should party autonomy be allowed as the unidroit principles? This remains an open and evolving issue in the Korean private international law, and I believe that it requires further clarification and perhaps restorative refinement. Thank you very much for your attention. I look forward to further discussion on these topics. Thank you.
Thank you very much, Professor Chun. That was a very succinct and very insightful presentation into the Korean private international law approach to carbon markets. We're running a little behind, but I'm going to look over there, and there is an OK sign. Fantastic. We're going to take a couple of questions, if we have any, from the audience. If you have any questions, would you raise your hand? And I think a microphone will magically appear at your side. Does anyone have any questions in relation to this, what we've heard on the panel this morning in relation to carbon markets? There's a question right there in the back, and there the magic is happening. You have the floor. Would you please tell us who you are and then ask us your question, please?
Okay, I am Kono Min from Ministry of Justice. I have a question related to forum shopping. So my question is very simple. What happens if two private entities conclude a contract related to carbon projects? An example might be assigning carbon rights or selling carbon permits and whatnot. And in the dispute settlement clause sets jurisdiction and governing law not intended in the perspective of, I don't know, international community. A good example might be trying to evade certain regulations by choosing a venue in a country in which that country is not a member state of Paris Convention and whatnot. Is such a situation a problem? And if so, what is the solution to actually stop such forum shopping?
Thank you very much for that question on foreign shopping. Professor Francina, you have the floor.
Thank you. Well, I will provide just an initial answer. Maybe others might want to add something. I believe a basic distinction must be made based on the nature of the dispute. The scenario you were referring to, if my understanding is correct, is that of a dispute of a contractual nature, which refers to a contract including a dispute settlement clause. That is one aspect, indeed. It has been said that many contractual relations are indeed entered into in the life cycle of a carbon credit. But other aspects too are relevant, and probably the focus is, at least at this stage of this project, much on these other aspects, the proprietary aspects. So to the extent to which the proprietary aspects are at issue, I'm not sure the dispute settlement clause will have a final word, because that dispute settlement clause will refer to disputes that are contractual in nature, and proprietary aspects will have an impact indeed, but will not be the very object of the dispute. I'm sorry, just to provide a very initial answer, but I'm sure others might want to add something more meaningful.
Thank you very much, Professor Francina. Anyone else with a question? I'm not seeing any requests for the floor. And then in light of the time then, it leaves me to thank the panelists that we have this morning on the private international law issues relating to carbon markets. We have then, and we'll ask you to thank with me, Ms. Amy Held, Professor Pietro Francina, Professor Fabrizio Pulido, Professor Chang Min Chun. Thank you very much for having been with us. Our panelists, would you give them a round of applause, please? Thank you.
Well, it was a delight to be present for such a compelling and forward-looking discussion. We will now take a short coffee break. Session 9 will begin at 11:15. Per usual, refreshments are available at the hall. Thank you. Ladies and gentlemen, the next session will begin shortly. Please return to your seats. We also ask that the moderator, speaker, and panelists for session 9 to take your respective seat on the stage. Ladies and gentlemen, we'll now begin the last session of the HCCH Asia Pacific Week, Seoul 2025. Welcome back, everyone. We are now ready to begin Session 9, Private International Law Issues on the Digital Tokens Project. It is my great pleasure to introduce the moderator for this session, Professor Chang-min Chun. He is concurrently a professor at the Seoul National University of Science and Technology and the vice president of the Korea Private International Law Association. Professor Chun is a leading expert in capital markets and financial regulation and served as chair of the License Committee for Virtual Asset Service Providers in recognition of his expertise in the field of virtual assets. I'm sure everyone knows the drill by now. Please keep an eye on your clock for the session to run smoothly. I now yield the floor to Professor Chun.
Thank you, Ms. Bak. Welcome to the final session, Session 9. So we have one speaker, Dr. Escola, and 4 panelists. Because some of the panelists and once Dr. Escola has already introduced, so I'd like to save the time. And then I'd like just to mention 2 new guests. First one is Professor Morishita Techo. He is really leading professor and scholars in the field of financial law and private international law. He is also actively participating in the Hague Conference digital token projects. I really hope to hear your opinion on these issues. And then finally, we have, yesterday he also participated in the other session, but I'd like to introduce him. He is Professor Guo Lee. He is a professor of law school at the Chung-Ang University, and he is vice president of Private International Law Association, and also he is chief vice president of International Law Association Korean branch. Because we do not have time, so I'd like to give the speaker 25 minutes. Is it okay? Okay, and then each panelist have 10 minutes or maximum 15 minutes. So remind 10 minutes, and you have at most 5 minutes. Okay, and first we'd like to hear speaker's presentation. Please give him a welcome.
Thank you very much, and hello again. I have the pleasure of speaking with you today on the Digital Tokens Project, of which there is an experts group at the HCCH. Quite a few of them are also on stage today. So I'll simply address the issues relating to the grounds for jurisdiction and the rules for determining the law applicable to digital tokens and to electronic transferable records. Lots of questions and few answers, but it would be interesting, I think, to look at the scope of what we are discussing. I'll try to be as brief as possible so we hear from our experts instead. As I've mentioned, in March of this year was established another new experts group, and this is the experts group on digital tokens. The HCCH experts group focuses on jurisdiction and applicable law rules in relation to issues that would arise from the use and transfers of digital tokens. Now, what are the issues? 5 that we managed to categorize. In terms of the issues, first, the core challenges for private international law, which are specific to tokenization and the digital economy. And these are 2 things. One, what is called the situs fiction. Essentially, because of the decentralization and the non-localization of the digital assets and the tokenization of these things in the space, there is no location to link these things or these tokens to. Moreover, a lot of them are now on distributed ledger technology, meaning they're distributed in nodes throughout the world, they're completely decentralized, and there is then an issue as well in terms of locating any sort of connecting factor or grounds for jurisdiction. The second core challenge for private international law is the pseudonymity or the anonymity associated to these tokens. So those of you who hold wallets, for example, will be very familiar with this, which is that you don't have your personal identification information linked to these assets. And as a result, there's a lot of pseudonymous and anonymous use of these sorts of tokens. That, of course, leads to the second thing, which is that the traditional ways we use, the traditional methodologies for private international simply don't work anymore. A lot of the CITES-based methodology just may not work. We don't say they do not work, they may not work. And there may be questions that arise in relation to the CITES-related methodologies that we use for private international law. Third, of course, decentralization enables what's called trustless global cooperation of these tokens, but of course at the same time it obscures location and identity. And fourth, the difficulty in locating property as connections to different locations may be simultaneous or may indeed be of equal weight. And lastly, of course, there are fewer objective grounds for jurisdiction and there are fewer connecting factors which are traditional and objective. What is the approach that we take? You've heard this already in the last panel. For digital tokens, we're also taking what's called the holistic approach, looking at jurisdiction, applicable law, recognition and enforcement, and possible international cooperation mechanisms as a whole, globally, before deciding on possible frameworks for rules for each of these. We have come with a working definition of what these tokens might mean. And at first, we looked at them as exclusively assigned data, including data representing an entitlement. These exclusively assigned datum is stored electronically and with features relying on decentralized mechanisms such as distributed ledger technology. Now you will note here that what we're looking on is actually the decentralization of these mechanisms and not DLT or the distributed ledger technology specifically. And the reason for that is the need for technological neutrality as we move forward. The technology on the distributed ledger itself brings the question of decentralization and non-localization. However, it may not be the only or the last technology that brings this question. And so in this project, what we focus on is the characteristic of decentralization as opposed to the technology, which is blockchain or DLT. What we've also done is started with a taxonomic study to ensure that our work is aligned with the existing regional and international instruments that have come before this work. And that includes, of course, a lot of the work that's already been undertaken by the United Nations, in particular the United Nations Commission on International Trade Law, UNCITRAL, our sister organization. We also look to other work outside of the UN framework, including the UNIDROIT principles on digital assets and private law. By mandate, certain tokens or tokenized assets are removed or excluded from the scope of this work. The first is securities, whether held directly or indirectly. And that is work that falls under a different basket in post-convention work that the Secretariat is carrying on as part of the 2006 Securities Convention's portfolio. We also exclude central bank digital currencies, which is the subject of another experts group at the HCCH, and that focuses also has implications on monetary sovereignty and the financial stability of the global financial markets. And as we've heard just a little earlier on, we're excluding from this work carbon credits. Now, the exclusion from the scope, however, doesn't mean that it's not in alignment. The Permanent Bureau is doing everything it can to ensure that the frameworks that come out of all of these projects are not only aligned, but also coherent and consistent with each other. Now, this is the chart that we're looking at in terms of all the private international law issues that may arise in digital tokens. The focus really is PIL as a whole, holistically, focusing first on the left side of this diagram, which are the green and the light blue boxes. Now, at the top, of course, you see the private international law considerations, and on top, and caveating any sort of PIL considerations are the overriding mandatory regulations, in particular, where digital tokens originate, transfer, are acquired on, or are dissolved, redeemed on markets which are regulated. So these overriding mandatory regulations would then caveat any sort of private international law framework that we are working on. On the left column, you see all the green boxes, which look to the choice of forum or the party's ability to choose where the dispute is heard. and the question of the grounds for jurisdiction. We're discussing questions of competence, whether there are certain jurisdictional grounds, what is the issuer, is there a central actor? Then the next column of boxes look at choice of law and applicable law. You've heard already the importance of characterization of the disputes, and here in digital tokens as well is an intertwining web of lots and lots of different kinds of relationships. What does this mean? All of us are tangible, living in the real world. When we're dealing with the digital economy, we're on a different platform. And usually, to enter that platform, you have to agree to terms and conditions. Now, I'm going to take kind of a show of hands in the room. How many of you are on social media? That includes WhatsApp, LinkedIn, Facebook. Come on, how many of you? Instagram, TikTok, YouTube? All right, a bit shy here. All right, so those of you on those platforms, when you first made your account, you would have had a very long list of terms and conditions. You scroll to the bottom, you accept. All of us, mostly lawyers in this room, how many of you actually read those terms and conditions? So you accept it. If you don't accept it, you don't make the account. It's as simple as that. Is that true party autonomy? Is there a weaker party that needs to be protected? Are those then simple contractual relationships? Now, what happens if you have a digital token, which is an avatar in the metaverse? Now, the metaverse today is a bit of a dirty word, but essentially it's all these immersive technologies that we're all involved in. It's simulators, it's gaming, and so on. It's a billion-dollar industry. And what are we thinking of? We're thinking of people spending good money in the real world, fiat currency, buying digital assets such as tokens, avatars, to clothe themselves, their avatars, to buy things in these metaverses. I'll give you an example. Decentraland is one of those metaverse-type universes, an immersive technology where you can spend real money to dress yourself in the latest fashion, so you can actually buy digital representations of what just went down the catwalk in Milan. For example, you could buy the latest Dolce and Gabbana, you can buy the latest Dior suits to put on, and they cost a lot of money. Those things, for example, that you exchange money from on that platform, are they simple contractual obligations you entered into? What happens if my avatar decides to walk onto your avatar? What if you go to Decentraland and buy a piece of property, let's say property inverted commas, in Decentraland, and you make a beautiful boutique there to sell your Dolce & Gabbana or to sell your Dior products, and right next to it, I buy a piece of land and set up a pig farm? Would you have a cause of action against me? Do I have property rights in these things? These are basically the questions that we discuss in the matter of characterization of these digital tokens that can be bought and are being bought and traded today. This means that there's a whole different kinds of consideration that we need to give to these disputes. Are they contractual? Are they torts and delicts? Are they contract-adjacent torts? Is it a proprietary issue? Is there unjust enrichment? What happens if my avatar hurts your avatar in the real world? And we go on then to haptic suits, and when they're cybernetic haptic suits, if you're wearing a suit, you know what a haptic suit is, of course, you put something on, and you have a really immersive technology, such that, for example, when you are shoved to one side, you feel it physically. If I hit you in the face in the metaverse, you will feel it too. What happens if my avatar hits your avatar and you feel it? If I'm sat in Seoul and you're sat in Tokyo, which law would apply? Did you agree to that on the platform? Is that simply a contractual issue, or does it become a tortious matter? What if I destroy your haptic suit or the cybernetic connections there? Is there a contractual breach, or is that really a proprietary damage that you are entitled to claim for? Those are the things that we look at. And below that, of course, you consider all the public policy considerations. Can parties choose? Do parties actually choose when it comes to digital tokens? Now, as I said, we acknowledge the work that has come before, and we also acknowledge then in this work that we do not fragment from the work that came before, including other soft law principles that have been come up with, including by UNIDROIT. Now, on the right side of this slide, you see two other columns, which are a little less developed. These are being considered holistically as we consider all the private international law issues, but are then to be considered a little later. And that has to do with the recognition and enforcement of decisions relating to digital tokens, as well as possible international cooperation mechanisms that would help us deal with the PIL issues that would arise in this very borderless, very decentralized world. So, what are the grounds for jurisdiction? These are the questions that we're studying today in the Digital Tokens Experts Group. The first, To what extent would the principle of party autonomy with respect to jurisdiction continue to apply to the different examples of tokens and their potential use cases? So in that sense, can parties choose the forum they go to when it comes to a dispute? Now, how would they express this choice? Is it expressed on the digital token? Is it expressed in the system? Can the users choose? Do the users actually choose? And how can this be accessed or discerned when the dispute actually arises? This is also important because digital tokens are increasingly used in automated contracts, in what's called smart contracts. Now, smart contracts are neither smart nor are they contracts. What they actually are lines of code that simply execute a certain action when certain conditions or criteria are met. In these cases, is there true party autonomy? Are parties' choices actually being expressed? These are the questions that we are asking. The next question, with respect to tokens and their potential use cases under consideration, what grounds of jurisdiction would merit further study? Are there new grounds of jurisdiction that could be developed or considered? In the absence or in the invalidity of a choice of court clause, what other grounds of jurisdiction may be applied to determine the appropriate jurisdiction? So even when parties choose, and if it's invalid, what do we do? And of course, you've heard this many times over today already. Are there overriding mandatory rules or public policy considerations that would prevent the application of a choice of law or choice of court clause or affect its validity, which are specific to certain examples of tokens? Then, of course, jurisdiction is important, but also determining the applicable law really is. Now, the only soft law guidance that we have in relation to applicable law is the UNIDROIT Digital Assets and Private Law Principles. Now, those principles are a set of 19, one of which, Principle 5, refers to the choice of law, applicable law, let's say, in proprietary matters. Now, that principle has a waterfall cascade, and it basically falls at the bottom to lex fori. We wouldn't know lex fori if we didn't know the forum, and that's why the grounds of jurisdiction may also be important for determining the applicable law. The grounds for jurisdiction, and therefore the court that is competent, would also decide which public policy and which mandatory rules would apply, and these caveat any sort of choice of law that the parties could make. So in determining the applicable law, these are the issues that the experts group would consider. First, party autonomy could, of course, be a potential solution which have been already promoted in many hard law and soft law instruments, both at the HCCH and beyond. Second, further work on connecting factors and characterization is desirable, including fallback rules to avoid reliance on lex fori. Lex fori is a particular concept which may be anathema to some people because it basically signals a fragmentation. When you go down towards the forum rules, first you need to know the forum, but second, the forum gets to apply whichever rules it wants, and therefore might fragment from a unified whole. Third, how is party autonomy to be expressed in the tokens or the systems? And here's a particularly philosophical question. In most of the industry that's dealing with tokens, the philosophy is not to choose the law and not to choose the court, which works perfectly if you actually have nothing go wrong. But the moment something goes wrong and a dispute arises, that's when all the issues start to come up as well. Of course, under this head, we're also considering the connecting factors for further study and whether there are overriding mandatory rules and public policy that should be considered. Now, these are the objective connecting factors that the experts group has already considered, both in the exploratory phase and its first working meeting that took place just a month and a half ago. First, we started with CITES as usual. The question, of course, of distribution and decentralization came up. But the question also came, could you have digital tokens on which there actually could be some sort of connecting factor via CITES? And could the CITES methodology still work? There's no need to fix something that isn't broken. From there, of course, came the consideration of the location of the issuer and then the location of the custodian of these tokens. The fourth thing that was considered was the habitual residence of the holders. And then fifth, the location of the person last known to have controlled the relevant private key, or where that person cannot be ascertained, where the last known transferor of the relevant digital asset was located. Six, we considered the locus delicit and exactly where this might be, followed by seventh, the location of the exchange. And eighth, and this was then discarded quite quickly, the place of the relevant administrator or the operating authority, or the place of the private encryption master key holder, known as the pro par or prema rule. This is not the rule that has been taken in several jurisdictions, and so was considered to be something to be discussed, but then maybe to be further studied. What are the questions that are being discussed? First, to what extent would the principle of party autonomy, again, with respect to choice of law and the rules to determine the applicable law, continue to apply to the different examples of tokens? How would this be validly expressed in the system, in the token, or by the user? And how could it be accessed or discerned? And the question here as well is, what is the scope of the applicable law? So once you find out which law applies, exactly what does it apply to? Only the contractual relationships? Only the proprietary interests? How about torts? How about unjust enrichment? And there comes, of course, some of the other issues that would arise, in particular where certain jurisdictions have laws that prohibit, for example, certain uses of tokens. In some cases, they prohibit, for example, Bitcoin. In some cases, prohibit certain kinds of cases. For example, the initiation of proceedings against persons unknown. Now, we understand, for example, the jurisdictions of Japan and Scotland do not allow suit to be brought against persons unknown. So there are all these other considerations as well. Second, with respect to the tokens, including the potential use cases, what traditional connecting factors would require further study? Or what new connecting factors could be developed? Third, in the absence or the invalidity of a choice of law clause, which connecting factors may be applied? Fourth, again, the public policy considerations that would prevent the application of a choice of law or choice of court clause or affect its validity. Are there specific tokens in which there would be specific considerations such as these? And of course, the same to mandatory overriding rules. Now, this experts group also then decided that instead of discussing this in the abstract, it was much more important to look at the concrete use cases. So why are we discussing this? It sounds like something you pull out of the sky. Who's really tokenizing? Are you involved in the tokenized economy? So we decided to look at use cases. And the first use case, which has its own work stream, is what we call electronic transferable records. And this is really focusing on UNCITRAL's model law on electronic transferable records, or MELITA, as is fondly known. MELITA has been adopted in approximately a dozen jurisdictions around the world, including Singapore, France. It's being considered in the Netherlands as well, and is being also adopted is being adopted by jurisdictions that have domestic laws aligned to MELITA, like the United Kingdom. MELITA is designed so that it does not displace existing private international law rules, which will be applicable to electronic transferable records. What does ETR, or electronic transferable records, mean? We're really referring to documents of title. So trade documents of title, that's what we're referring to. And so this work stream really is coordinated development of PIL rules and guidance by the HCCH, which will follow on an UNCITRAL instrument. It is the first kind of project like this that will actually follow on to another sister organization's instrument and provide PIL guidance in relation to a standing document. So therefore, it takes on the UNCITRAL principles of functional equivalence, technology neutrality, which we already have at the HCCH, but it then deals with ETRs as defined in MELITA. The second use case is Bitcoin. And this is the example of the fully decentralized implementation of a token. And of course, the question then arises, in cases involving Bitcoin, you'll be very familiar with the coin case from Singapore, and all the other Bitcoin cases, that's actually the biggest use case at the moment. What kind of private international law questions would arise? The third are commodity-linked or backed assets. Examples being stable coins. And the question is how to link this. Now, when you have a commodity-linked or backed asset, you basically have three components. You have the real-world asset. So, for example, you might have a ton of gold. Gold is the real-world asset. Then you tokenize it, and there is the digital asset. That token is the digital representation of the gold, and in between is that link. And the question is, in relation to jurisdiction and applicable law, what is the law applicable to the token and to the link that links that token to the real-world asset? The real-world asset is easy, it's cited somewhere, it's located somewhere, it's a thing that exists. But these two other components are not. And so in different jurisdictions, there are different ways of dealing with the link and with the intangible, which is the digital token. Examples of this are stable coins, which are baskets of these assets, digital assets, bundled together as in one coin, and commodity-backed coins such as agriculture-backed tokens, which are now in great use in South and Latin America. And there are, of course, other secondary use cases as well, healthcare tokens, where your healthcare data can be tokenized on a coin and used to, in exchange for healthcare services. There are soul-bound tokens, which are identity-based. They can be created and destroyed, but never transferred in principle. And these would be, for example, Harvard University tokenizing their degree certificates. They're non-fungible tokens. These NFTs always remind people of these bored apes, these very ugly monkeys that they sell as art. It's gone beyond the art world now and also refers to other kinds of non-fungible tokens, such as, for example, electronic documents of title, trade documents that are also non-fungible. Governance tokens and decentralized autonomous organizations, these tokens allow you to vote in a certain way in running your organization. And there are, of course, stake tokens and consensus mechanisms as well, the same kind of governance type tokens that deal with the governance of certain kinds of organizations, which now run trusts and charities across the world as well. That gives you an oversight of what we're doing at the HCCH in relation to digital tokens. I hope I've kept within my time, but then you hear from the panelists as well. Thank you very much for your attention.
Thank you so much. It was a perfect overview of the current HCCH digital token projects. Thank you. And next we have first panelist speaking presentation, Professor Polido. He will, I think, present some perspective of digital token from the perspective of Latin American law. Thank you.
Thank you. So, good morning again, everybody. I hope you not get bored to listen me to again, but now I'm turning to a specific topic related to digital tokens in private international law, and my task here is to cover some of the achievement and also findings from a search that was made between the American Association of Private International Law, to which I am a member since 2010. So it reunites the scholars in the Americas specialized in private international law, similar to the Korean Association of Private International Law and European Association of Private International Law and other organizations. And this was the work also made in connection with the Digital Tokens project last year. So my proposal is to cover the adoption and usage of tokens in digital in Latin America and the implications for private international law and tokenization. We are discussing here an emerging topic in digital economy. So this is why it's so interesting, fascinating, compared with the other emerging topics related to private international law, emerging fields, as to say, and also the converging trends in Latin America related to digital economy and particular impacts of digital economy to private international law. The trans-jurisdictional legal challenges is something that I quoted as the core of the presentation because we identified in Latin American jurisdictions what could be the potential major challenges in connection with jurisdictional rules and how jurisdiction is still a very important aspect relating to digital tokens, in particular due to the decentralization or decentralized nature of those institutions, categories, and also transactions, and also the importance of a coordinated global framework to deal with digital tokens, as we know. So if we go to Latin American figures and indicators, we find that most of the countries in Latin America are very inclined to use digital tokens in the economy. There were like a huge increase year over year relating the use of digital tokens, but also we find that there is a kind of regional approach to those tokens that are mostly used in daily transactions in Latin American countries. Latin American countries are considered emerging digital markets from one side, and second, there is a huge considerable digital penetration rate in those countries, such as Brazil, which is the fourth largest digital community worldwide. So this is an important aspect where Brazilian in marketing institutions started dealing with digitalizing finance and commerce, trade, and how this had a huge impact over international commercial law, private international law in the last decades. So most used tokens in Latin America range from payment tokens, agri-tokens. Jerry mentioned this in her presentation because they are a very specific type of digital token that is used in connection with a sector of industry or commercial, in case the trade of commodities, and stable coins, utility tokens, and NFTs. All of them, including, were somehow mapped, identified during this exploratory work of the expert group on digital tokens carried out by the HCCH. And also unique payment token-based technologies by which transactions protected by replacing the digits of account numbers with a unique token or digital identifier deployed in different devices or stored in the cloud. And I will just make a detour in my explanation here to go back to Amy Hell's presentation in last panel, in which she mentioned the importance of actors, players, subjects in those kind of transactions. Because if we identify who are those subjects or parties, actors, we will, in the end of the day, in a stage of analysis, understand how those transactions are based not only on decentralized nature of networks, first of all, or pseudonymity of users. So who is the user? In fact, where is the user? And so connecting factors are still relevant when we talk about private international law implications in relation to digital tokens. But also, what's most important in this case is the way how the chain of transactions can be also characterized in under different perspectives, from proprietary, from contractual, non-contractual, or tortious. And this is something very unique because this is how this holistic approach to private international law aspects to digital tokens is taken by the HCCH in this current project. Why it's so important? Why it's not just concentrated or focused on a particular aspect of proprietary nature of a thing or a digital asset as carried out by UniDroit, for example, making the distinction between the instruments and also the policy approach behind the adoption of principles on digital assets. This is just a unique distinction that we have to make in order to understand the role of private international law in those areas. And so when you talk about Latin America, we will see the agri-tokens, which are very important, especially because they are being adopted in several jurisdictions and they can be used for several purposes, from trade uses, permutation, collateral for loans and trade finance. And so that's also very important for actors such as farmers and also cooperatives dealing with digital trade on commodities. So this is also something important for private international law purposes. The implications for private international law and tokens in Latin America will lead to three important conclusions. I would say preliminaries in conclusion, that we are discussing distinct categories of digital tokens really used and deployed in the region, first of all. Second, there is a regional usage diversity, which was clear during the responses collected in the joint research between ASADIP and HCCH last year in this joint survey questionnaire that was shared amongst the participants. And so that's important to understand the multiple contexts and legal regimes where those tokens are applied, deployed, used, for example, property, contractual, tortious, and also regulatory. And of course, the market scale and institutional participation of actors which demand clear PLL rules on applicable law, jurisdiction, and enforcement. And so the main core issues that were raised by participants in the joint survey, which is reunited and collected in preliminary Doc 4 submitted to CGAP this year, is related to the 4 basic areas or clusters of private international law, ranging from applicable law, jurisdiction, recognition, and enforcement, and also the role of party autonomy, particularly because the region, the Latin American region, has several and a traditional, I would say, approach to party autonomy during the 2 centuries, especially because the first PIL treaties adopted in the region were back to the end of the 19th century. So party autonomy always had a very important, I would say, role to play in those discussions regarding any aspects of cross-border transactions, and in particularly in this case, the frictions or tensions between party autonomy and also public policy and further overriding mandatory rules consideration. So this is something very unique for our countries. In converging trends, which are the outcomes of this research, and I will leave to you, are those related to shared legal concerns in relation to a PIL policy and also other regimes, for example, property contractual issues, consumer protection, the anti-money laundering, CFT, countering and financial of terrorism that could be associated to those transactions, but also the emerging legislative regulatory experiments in domestic jurisdictions, Argentina, Brazil, Mexico, the role of soft law doctrine in regional courts in carving and in shaping that particular understandings regarding the use of tokens in PLL issues, the emphasis of party autonomy is the lex loss solution, lex contractus, as Jerry mentioned as well, the proper use of connecting factors to avoid a lex forism approach to those transactions. And of course, the global recognition and circulation of decisions rendered by domestic courts involving token transactions, and all those are very important. And to finish, of course, I will leave this presentation because the time is short, but what is major important issue in this discussion is related to the avoidance of fragmentation of legal approaches beyond Latin America, the legal certainty in cross-border token transfers and decentralized platforms, why conflict of laws or private international law has to deal with those major issues and concerns, and also to understand why jurisdictional grounds remain elusive and ill-suited for decentralized ecosystems. In the last years, I have been devoted, at least from my research practice and agenda, to those questions that arise from jurisdiction and decentralized platforms. And this is a very important topic because we are discussing this in the EG as well. And final, that a coordinated global framework is necessary because we are talking about the role of international organizations in 3D, digital commerce, digital finance, and digital economy. So 3 dimensions of this policy work that has been done by several organizations, but also because the HCCH mandate in the field of private international law, I have been insistently defending this as several peer colleagues which are working hard in those expert groups, that the HCCH has a mandate unique in the field of private international law, which is historical and overarching. It's a public international law matter. The statute of HCCH in Article 1 is focused on the role of the organization in the way how the organization design, discuss, adopt, harmonize in uniform rules in private international law. And also the potential way for harmonization, party autonomy, digital tokens as a distinct category, and whether a question I still have, I will give back to my colleagues, whether POL still has to be a technology neutral or technology oriented in relation to digital economy. So thank you so much, and I'm sorry for exhausting the time here.
Thank you. Thank you so much, Dr. Polido. It was another wonderful, succinct overview of Latin American situation. And next, we have panelist Ms. Amy Held. She will, I think, cover the case law of UK, right? England and Wales. Please give her a big applause.
Okay, thank you. A pleasure to be back and speaking about something completely different this time. And in the interest of time, I'll just get straight to it. So as you can see, we have been very, very busy in the courts of England and Wales with claims concerning crypto assets. Our first case was 2018. And as at the 30th of April this year, we have had 22 cases that I'm aware of at least. And all but one of these involved a live issue of the grounds of international jurisdiction. Now, I've listed here only the cases that really mark some kind of significant development in procedural terms, but the two I think that are quite interesting for this audience is Osborne in 2022. This was the first case in which service of proceedings was solely done by NFT on persons unknown, and this was authorized by our courts. And then the second case of interest is probably Taimo Shan in 2024. This was our first application for the recognition and enforcement of foreign judgments concerning a claim relating to crypto assets, and this was a judgment of the courts of New York. So that's the overview of these cases. Before I say anything about them in depth, I do think it is very important to start with some preliminary points of procedure to contextualize the procedural context in which they're being brought. I will try to whiz through these as fast as possible. So in the common law tradition, jurisdiction is conceptualized in terms of service of proceedings on the defendant. This is historical, it goes back to the 12th century, but the core point to note is that much of the discussion around rules of jurisdiction center on whether and when it's lawful to serve proceedings on the defendant. Okay, so from this, we take a really territorial approach to jurisdiction. If you have a defendant who is physically present within the territorial borders, you can serve proceedings on them as of right. If your defendant is not present within England and Wales, then you must apply for the permission of the court to serve them out of the jurisdiction. And it's largely service out of the jurisdiction that we're concerned with in the international context. So I am just going to go a bit further through to the real point that's important. This is the doctrine of precedent, and I think this is really important to discuss because not everything a common law judge says is binding legal authority. I think as civilian lawyers, you're all aware that in our system of law, the law is judge-made. But just because a common law judge has said this, doesn't mean that this is law. Okay, so strictly speaking, only decisions of the Court of Appeal and the Supreme Court are binding authorities. Anything below this, such as the High Court, and below are not considered legal authorities. So if we are looking for the common law position on international jurisdiction, we look to cases of the Supreme Court. Okay? Now, the really important thing to understand about the crypto asset cases so far they have been applications for service out of the jurisdiction. And these applications are heard by a high court judge or a deputy high court judge. So I think you're all starting to realize the point I'm trying to make. The 22 cases I mentioned at the outset of this presentation are not binding legal authorities. All but one of them remained high court applications at the ex parte stage. One of them did go to the Court of Appeal, but it was on an issue unrelated to grounds of jurisdiction. Okay, so having said that, I'm much more comfortable discussing the cases themselves. Okay, so all of these have been applications for service, applications to serve proceedings out of the jurisdiction. Typically, you've had applications for ancillary relief, freezing orders, information orders and proprietary injunctions, and there are very few reported challenges to the jurisdiction. So what's important to understand is at the application stage of service out, this is done with only the claimant present. The defendant will be given a chance later on to come and contest the jurisdiction, but at the application stage, it is ex parte. Okay, the causes of action have generally been tort claims relating to civil fraud. We've had a few proprietary claims, but these have been a little bit less common than our tort claims. So, what have our cases been, how courts generally been doing so far? So, one of the causes of actions or the gateways to international jurisdiction that have been relied upon is Gateway 11. This is called our property gateway, and in international terms, it's our local expression of the forum situs rule. So it's been asking our courts to determine where is a crypto asset located for the purposes of international jurisdiction. And what the courts have been doing, because the parties are submitting these kinds of arguments to them, they have been referring to a proposal made by Professor Andrew Dickinson in a book chapter called Cryptocurrencies in the Conflict of Laws, which was published by OUP in 2019. Now, the proposal itself was in terms of applicable law, and it was a very highly nuanced, sophisticated proposal relying on a contractual characterization of certain relationships arising in a blockchain network. And the rule that Andrew proposed was to apply to a very specific relationship arising in it. So in sum, the gist of the proposal was, for this particular type of relationship, the proprietary effects outside a cryptocurrency system shall be governed in general by the law of the country where the participant most closely connected with the participation in dispute resides or carries on business at the relevant time. Somehow, during the course of litigation, that particular proposal took on a slightly different life of its own. And litigants and judges are generally talking about a proposal that the lex situs of a crypto asset is the place where the person or company who owns it is domiciled. So that's not quite what Andrew has said, but the courts and practitioners are tending to attribute that proposal to Andrew. Okay, later courts have started to recognize that there is a discrepancy between these two things. So all in all, our cases so far on Gateway 11 are a little bit shaky. They're not really disclosing any sound legal reasoning. Gateway 9A is a gateway, or it provides a ground of international jurisdiction for claims in tort, where tortious damage is sustained within the jurisdiction. So this is our local equivalent of the forum locus delicti rule. And again, the courts are doing something slightly odd. They've identified no fewer than 6 different ways to say that damage occurring in a crypto tort occurred in England and Wales. And if you read these cases in depth, the decisions are inconsistent with one another, and they don't really seem to add up to any of the general principles we apply for international jurisdiction for tort claims. So the main reason why I had wanted to talk a little bit about civil procedure was to explain why the cases so far seem to be showing some very odd legal reasoning before the courts. And this is because in the High Court, we are not concerned with arguing legal principles, and the courts are not concerned with rendering exemplary examples of common law reasoning. This kind of thing is done at the Court of Appeal or at the Supreme Court. In the High Court, we are much more concerned with practical considerations, litigation tactics, the practical concern of the parties, and in an adversarial system of procedure, this is what is driving the case before the court, and a judge is not entitled to depart from what's being submitted and to apply what they think is the correct solution on any given case. And this is why we have a doctrine of precedent at all. So the first sort of main point I'd like to make about our cases so far is they say very little about the common law position in relation to international jurisdiction over crypto asset litigation. To understand what's really going on in the crypto asset litigation before our courts, we have to understand why the cases are coming at all. Now, all of the cases, all but 2 of them, had concerned online fraud, such as hacking or phishing, where a victim is fraudulently induced to send crypto assets to a particular blockchain address on the basis that they're making a valid investment or they're making a legitimate payment. Once the victim has been, once they've realized that they've been scammed, they've got absolutely no idea what to do. Because everything has happened online, they're not sure who is responsible for this fraud. It's impossible to track down which particular person was engaging with them online. Everything that happens on the blockchain is pseudo-anonymous, and so they've got no idea where their crypto assets have gone. The only thing they know at this point is the address to which the crypto token had been sent. So what they'll do then is they will hire a specialist technology investigator who is able to trace the crypto asset they transferred through the blockchain, through different addresses to work out where this crypto asset has gone. And normally this exercise stops when you identify a blockchain address that you can link to a person in the real world who can be sued. And these entities tend to be crypto exchanges. So at this particular point, and in these circumstances, what the claimant really wants is for the exchange to help them identify who's responsible for the fraud, where have my crypto assets gone. And this is why they've been applying for interim relief at the application stage for permission to serve out. They want information. They want the exchange to give up the information. They want, if the exchange still has that crypto asset at their address, to freeze it there until they can work out what's happened. But this is a little bit problematic under the civil procedure of England and Wales. If you want to obtain an information order, you have to say that you are going to bring a claim. The substantive claim is going to be brought in England and Wales. And the reason we have this procedural requirement is actually because the UK is a party to the Hague Evidence Convention. So if you want information, this counts as evidence. And in order to do that, you need to show that the requesting court is seized of the main proceedings. And so this is the core reason why some of our cases on crypto assets are a little bit funny on the reasoning, because what claimants really want to do is get around this procedural obstacle that they need to get this information order. And so the Law Commission has recently said in a consultation paper on digital assets and electronic trade documents in private international law that the procedural requirements that are involved in service out applications are transpiring to be an obstacle to access to justice in the crypto asset sphere. And a major cause for the inconsistent interpretations of our grounds of international jurisdiction have arisen because at this stage of the proceedings, the courts have a very natural instinct to provide a remedy to a claimant, and they will work out the sort of principles of it all later. But what's being asked immediately is, please give me an interim remedy. The courts have been saying yes, and as a result, some of our grounds for jurisdiction has suffered. So what the Law Commission has done is proposed a law reform that would assist a claimant in these kinds of situations without having to go through the usual procedural requirements. What it has also done is offered some more principled interpretation of our grounds of international jurisdiction. I will not go through them in depth because these are available in the consultation paper. What I do want to finish with is just some concluding thoughts on what we can actually say about the position in England and Wales following these cases. So the common law position actually remains unclear. So 22 cases sounds like it's a lot, but what we really need for an authoritative common law position are some more cases at the appellate level that have been fully argued with both parties present. The second thing I'd like to say is that the 22 cases do need to be treated with some caution. Not every case that comes out of the courts of England and Wales are treated as relevant for binding common law authority. The cases are perhaps useful and interesting in that they show us the kinds of facts from which crypto asset litigation will arise, the kinds of situations that legislators will have to address if they are thinking to bring their crypto asset laws up to date with how these things are used in practice. The final thing I want to say is that the Law Commission's final report, following its consultation paper, will add considerable certainty to the legal position, and this report can be expected early next year. Thank you very much.
Thank you, Amy. It was a really good overview of the current movement on the England and Wales Law Commission's kind of reform project, right? Yeah, so I'm really disappointed that we do not have enough time to discuss the whole things, sorry. And then we have another panelist, Professor Morishita, and he will also cover Japanese case law and some other current developments on the crypto assets. Okay? Yeah, please give him a big hands.
Thank you very much. First of all, I would like to express my gratitude to HCCH and also the Korean Ministry of Justice for inviting me to this great event. And it is my great pleasure and honor to be here as a panelist. And I would like to discuss the challenges of Japanese law in this area. And first of all, as Amy mentioned that the UK position is still unclear. Of course, Japanese law's positions remain still unclear. However, I think that it might be useful to look into some typical situations that the property issues or contractual issues became disputed in relation to digital assets. So, yeah, in my presentation, I'd like to discuss some Japanese cases. And after that, I'd like to talk about some typical situations. And then I want to mention my tentative thoughts on some typical issues. Here, I listed 8 cases in which some issues on digital assets or crypto assets are disputed. The first one was the case in the Mt. Gox insolvency cases. As you may know, the Mt. Gox was a Japanese company, but most of its creditors were foreign residents. And in this case, the creditor disputed and tried to recover his Bitcoin deposited in the Mt. Gox, arguing that he is the owner of the Bitcoin. But a Japanese court rejected that under Japanese law, ownership cannot be obtained on the crypto asset because it is intangible. But in this case, no mention on cross-border element or PIL issues raised. And from the case 2 to 6, again, there is no mention on cross-border issues. The 7th case, this is a criminal court cases, but one of the issues is where the computer fraud occurred. And the court said that where in Japan there is a one node which made a record of the fraud transaction, and therefore, from the criminal purpose, it is sufficient to say that computer fraud occurred in Japan. But because this is a criminal court cases, I'm not sure if the same could be said in civil cases. And the final one, the number 8, this is a new case and it touches on the PLL issues. So I'd like to focus on this number 8, case number 8. Yep. In this case, the plaintiff corporation in the Virgin Island held the Bitcoin in Kraken, the California crypto asset exchange. And its account in Kraken was hacked by someone, and its Bitcoin was stolen. And after a series of transfers, the Bitcoin arrived at the account held by the defendant. Defendant is the crypto asset exchange, which is regulated under Japanese law. If the if the defendant noticed that, oh, this is a stolen asset, the defendant might have frozen the asset. But at that time, the defendant didn't notice that, and Bitcoin was moved to other places, and it has already become impossible to trace further. So the plaintiff succeeded to identify that the Bitcoin was held in the account of the defendant at some time. So the plaintiff sued the defendant, arguing that because of that, the defendant's tortious act, his property right was infringed on. The plaintiff lost its property right. And it argued that if the defendant performed its AML duty and noticed that it's a suspicious transactions, the Bitcoin was stolen one and freezed, his property right would not be lost. So this is the reason why the plaintiff brought a tort action in Japanese court. And because this is a cross-border transactions, the PIL issue is called, and this is the essence of the plaintiff's argument. It's a bit complicated, but I'll try to explain in a simple form. First of all, though that this is a tort action, plaintiff argued that first, its property right must be decided as a separate legal issue, and that such kind of property right issues need to be decided by the law of the location where the property right was acquired. And the location of the place of the acquisition was, according to the plaintiff's argument, it was the location of the crypto asset exchange where the plaintiff kept its Bitcoin, that is California. And plaintiffs argued that under California law, it had a property right on the Bitcoins. And after that, plaintiffs argued that in this case, when the tortious act occurred, the Bitcoin was held in Japan. And under Japanese PIL law, plaintiffs argued that effect of property right should be governed by the law of the jurisdiction where the property existed when the tortious act was conducted. So it means that the effect of the property right should be determined under Japanese law. But plaintiff argued that because it had obtained the property right under California law, Japanese law should recognize that, should treat its property right as ownership, which is analogical, similar right under Japanese law. And his property right, his ownership under Japanese law was infringed on because of the tortious act. So his claim for the tort should be allowed. This is a logic, very complicated, but this is a logic raised by the plaintiff. In conclusion, basically, the judgment dismissed the plaintiff's claim basically on the substantive law issues. The court said that under Japanese law, no ownership should not be enjoyed by the customers who indirectly hold the Bitcoins and who do not have the secret private key by themselves. And so in this case, the plaintiff's claims are rejected in such kind of reason. But the court mentioned some thought on the private law, private international issues. So first, If a tortious act infringes on property rights related to cryptocurrencies, which country's law should apply? The court accepted the argument by plaintiff and said that before discussing the tort issues, whether or not the customer had property rights should be determined based on the governing law of the property. And which country's law should govern the property right over the crypto asset managed by an exchange? On this issue, the judgment doesn't make clear answer, but it said that there is a room to consider that the most closely related location of the plaintiff's holding on the Bitcoin in question is the location of the exchange. Finally, in this case, first, the property right may have been acquired by the plaintiff, and the Bitcoin moved to Japan. And in such case, whether the property right established under California law should be respected or should be recognized also in Japan could be an issue. And in this respect, on this issue, the court said, even if the plaintiffs were to have property right under California law and the Japanese law, individuals who indirectly hold cryptocurrency are not recognized as an owner. So it means that the court said that such kind of ownership, which might have been acquired in other law, cannot be recognized under Japanese law. This is the case. So next, I'd like to move to the typical situations where jurisdiction and governing law may become an issue. As we saw, the previous case is one of the example, but recovery and seizure of stolen cryptocurrency is one of the typical situations. And Amy mentioned that in England, most cases are relating to this and try to get a jurisdiction. And in Japan, we do not have the cases on jurisdiction in such respect, but also in Japan, how to identify or how to get the information regarding the defendant or the party who stole the asset might be a difficult issue. And also in Japanese law, it is impossible, in my understanding, it's difficult or impossible to start litigation without identifying the defendants. So such a kind of issues should be discussed further in order to address the difficulty faced by parties. The second, the right of customers or duty of crypto asset exchanges. This is one of the typical situations where the dispute occurs between the crypto asset exchange and the customers. And also insolvency cases, we experienced 2 insolvency cases, Mt. Gox and FTX. So parallel insolvency might be also the situation that a difficult issue occurred. And the tokenization, also in Japan, the tokenization of asset has become popular. So various PR issue may occur in relation to such tokenization situation. Then I'd like to briefly touch on some issues. And first, identification of the location of crypto asset. And I think that instead of looking into the blockchain's mechanism, probably we should focus on the identification of location of the defendant or of asset. So as I mentioned, we do not have the parties, persons unknown type of lawsuit. So probably we need to develop some thought or theories or measures to get more information regarding the identity of the defendant. Or I'm not sure it is possible, but recognize some parties unknown types of lawsuit. Regarding the jurisdiction, as the same as England, Wales, probably we need to locate. We need to address the issues how to locate the crypto asset, especially in case that the law jurisdiction based on the location of property are the issues. Regarding the governing law, how to determine the link between the digital asset and real asset may be an issue. And also, as already mentioned by my colleague panelist, the property issues, whether or not party autonomy could be recognized or allowed in relation to the property issues might be important issues. In this respect, I think that also under Japanese law, some kind of party autonomy relating to property issues should be allowed, because that already property issues in relation to personal claim, such as the third-party effect of the assignment or pledge of contractual claim, have been governed by the law chosen by the parties. So I think there's a possibility that Japanese law could recognize party autonomy in relation to these kind of issues. Yeah. And also the final one, final slide, governing law on property right. As we discussed in the case number 8, the Bitcoin moved from one country where the property right was established and to the country where the property right cannot be recognized. So digital asset will be circulated in the hands of the parties in the various jurisdictions, whether or not we should recognize or respect the property right once created one jurisdiction in other jurisdiction could be one of the difficult issues we need to consider. Okay, thank you very much.
Thank you so much, Professor Morishita. It was an interesting case, Tokyo District Court. And then I also thank for your thoughtful opinion on the crypto asset in the private international perspective. Finally, we have Professor Gyo Lee, and he will also deliver some Korean cases with respect to crypto assets. Please give him a hand, give him a big hand.
So I'll discuss the applicable law of the cryptocurrency and the virtual asset in Korea. First of all, I'd like to, the feeling that, and I admire the Minister of Justice in Korea to co-host this event, because 7 years ago, the former Minister of Justice in Korea declared that shutdown. Possible shutdown of the cryptocurrency exchange. So it's a quite of a tectonic the shift. So there's so many cryptocurrencies, including the Bitcoin, Ethereum, and the Solana, and the Tether, and USDT run by the Tether, USDC run by the Circle. What else? And ADA. Run by the Cardano, so many coins. Do you know why I knew very well about the cryptocurrency? Because I owned them to study private international law. Today, I'll just describe the definition of the legal nature of the cryptocurrency throughout the lens of the case law. Also, I would show you the definition and the legal nature of the virtual asset in Korea. Also, we can get some implications from the case law related to cryptocurrency and virtual assets. Even though some of them is, I think one is the international case. But the rest of them is just a domestic case. But we can extract some, the hypothesis from those cases. So even though it's a criminal case, the Supreme Court does say the dependence acquisition of the bitcoins may be prohibited because bitcoins are intangible property with a property value, and the bitcoins are subject to forfeiture are specific. That's the court rulings. So in another case, Seoul High Court held that the cryptocurrency is a type of electronic money that is recorded in the electronic form of a computer and transacted over the internet without physical goods, and characterized by the operating and the decentralized system that use the blockchain technology such as Bitcoin and Ethereum. And that this is, the court said the cryptocurrencies can be issued in two ways. It's very specific under this court, the holdings. Either by building their own mainnet or by using the existing blockchain mainnet. In other words, the process of issuing cryptocurrencies involving the issuing tokens based on the existing blockchain mainnets, developing and building on the independent mainnet, and converting tokens based on the existing mainnets into coins based on the newly built independent mainnet. However, as developing and building an independent mainnet takes a considerable amount of time and funds. Funds are often raised through the token sales, whether or not it's a private or public, or a token listing between the steps 1 and 2 above. So due to the lack of the legislation on the cryptocurrency, the use of the cryptocurrency related to terms is not clearly defined, unified. But in general, cryptocurrency that have established their own domain, the network, that is cryptocurrencies converted in step 3 above, are called coins, and cryptocurrencies that cannot establish their own mainnet, the main network, part of the mainnet networks of other cryptocurrencies such as Ethereum and Quantum. That is, cryptocurrencies issues the step 1 above, or called tokens. So among them, tokens, those tokens, the one based on the Ethereum is called in the J token. So there's some difference between the cryptocurrency and tokens. Also, the cryptocurrency can be classified as two groups. It's a platform, cryptocurrency, and I think what is it? Stable coin. So another the case is here. This court, the Supreme Court held that the virtual assets, not the cryptocurrency, virtual currency are digitally represented in information with the electronic value assigned by the encrypted distributed ledger, such as blockchain, that is not controlled by the state and constitute the property interest. So I think the Korean Supreme Court used in the term the definition of the defined the virtual asset very narrowly, because it used to be you have to use the encrypted technology, otherwise it cannot be categorize the virtual asset. So those are the same trend followed by the Korean Supreme Court. However, let's just show you another the act. Recently, the act on the protection of virtual asset users was promulgated. According to this act, Article 2 prescribes the virtual asset as electronic certificates, including all associated rights that have electronic, the value, and that can be traded and transferred electronically. So it does not require the encryption technology. So this is we should follow in the end. So I think that we can anticipate that the ruling of the Korean Supreme Court will be changed in the near future. So there is some cases law related to cryptocurrency and virtual assets. This case, first case, is regarding it regards whether foreign national plaintiffs can seek the return of the funds directly from the exchange, rather than through a bank account whose holder was identified with his real name. This is an international case, but but court is silent about the choice law rules. Is not a good case, but it dealt with the cryptocurrency case. So here the issue I said whether the American plaintiff can seek the return of the funds directly from the exchange without going with the real name verification account, especially a K-Bank account. So the next one is about related to cryptocurrency, the claim for the reimbursement. Next case is related to tort claim. And the next claim is regards to whether the usury, the laws and the lending laws apply to restricted the maximum interest rates in the terms of the cryptocurrency lending agreement. So another one is related to contractual relationship between the crypto exchange and the user. Okay, the next one is that concerned that the liability for damages due to the hacking of cryptocurrency exchanges. So overall, we need to find the choice of law rules related to from the real case. So the first one is related to whether a foreign national or plaintiff can seek the return of funds directly from the exchange. The next one is the claim for the reimbursement. We can discuss the applicable law of the tort claim, including liability for the damages due to the hacking of the cryptocurrency exchange. So the other two is whether usury laws and the lending laws apply to restricted maximum interest rates in terms of cryptocurrency lending agreement. And the last one is the contractual relationship between the between the crypto exchange and users. And these are the list of the raised by the Korean the court, so we can discuss the applicable law of these cases in the future. Thank you.
Thank you so much, Professor Kyo Lee. It was another interesting introduction to Korean case law with regard to crypto assets. As Professor Lee mentioned, there's no Korean PIL cases regarding crypto assets yet. So because of time, I try to finish this session as soon as possible. But I believe that the important points of each speaker and each panelist was well delivered. If you have any before closing this session, even though we do not have time, I'd like to have one question or two questions from the floor. Is there any questions? Thank you for your cooperations. So now let's close this session. Thank you so much.
Thank you to all our speakers and moderator for an insightful and engaging discussion. I believe the session provided a timely perspective given digital economy's increasing role in global affairs. We will now take a short recess and reconvene at 12:45. Please help yourselves with refreshments available at the hall. Distinguished guests, the closing ceremony is about to begin. Please return to your seats. Before we move on to the closing ceremony, we have the pleasure of hearing a brief introduction to the Asia-Pacific Justice Hub of Seoul. We will begin with watching promotional video of Seoul.
Here is a shining city. A place where you breathe in green, see art in everyday life. A place where you can experience novelty with convenience. A place where smiles are everywhere. A city of exceptional elegance. A city full of excitement. When we are happy today and looking forward to tomorrow, Seoul is coming out now. Seoul's smart technology is unique. Tender actions are transforming everyday life.
I will pay with the Seoul coin.
Inclusive digital technology makes life convenient. We dream of a smart city everyone can enjoy together.
Seoul Cultural Belt. Do you want to follow?
When people are connected, it becomes a festival. When people in space are connected, it becomes a culture.
Keep following.
A city where daily life becomes art, and art becomes daily life. When we are happy today, we look forward to tomorrow. While we are enjoying Seoul, the day becomes short. Let's look forward to another day in Seoul.
Draw me the future of Seoul.
The future is not about predicting, imagining it. And imagination always becomes real. The imagination of Seoul that will lead the future of Korea. With happiness, Seoul.
Now, Mr. Sung Soo-jeon, the mayor of Seoul, will present key vision of Asia-Pacific Justice Hub. With a distinguished background in public administration and a career that began with the highly competitive civil service exam, he is now leading efforts to develop the Seoul legal town into a key legal hub for the Asia-Pacific region. Mr. Mayor, would you please come up to the podium? 전성수 청장님 무대 위로 모시겠습니다.
안녕하세요. 서울 서초구청장 전성수입니다. 헤이그 국제사법회의 아시아 태평양 대표단 여러분을 대한민국 서초구에 모시고 아태 사법정의 허브에 대해 소개할 기회를 갖게 되어 매우 뜻깊고 영광스럽게 생각합니다. 지금부터 서초구의 아태 사법정의 허브가 어떤 비전을 갖고 추진되고 있는지 말씀드리겠습니다. 먼저 아태 사법정의 허브의 비전을 간략히 말씀드리겠습니다. 첫째, 국내외 법률 학술 대회와 교육 문화 프로그램을 통해 법률 접근성을 높이고 법률 문화의 활발한 교류 중심지를 만드는 것입니다. 둘째, 서초의 법조 인프라를 활용해 문화적, 경제적 가치를 창출하여 브랜드 가치를 높이는 것입니다. 셋째, 대한민국을 넘어 아시아 태평양 지역의 사법정의 중심지로 성장하여 국제적인 법률 교류의 허브가 되고자 합니다. 잘 아시다시피 헤이그는 평화와 정의의 국제도시로서 ICC, ICJ, PCA, 특히 HCCH가 위치해 있고 여러 차례 평화회의가 개최되기도 했습니다. 또한 국제기구 방문 프로그램, 국제법 교육 프로그램, 법, 정의, 평화와 관련된 컨퍼런스가 활발히 열리는 국제사법의 중심지로 자리 잡고 있습니다. 이처럼 국제법의 수도로 불리는 헤이그를 모델로 삼아 서초구는 대한민국 최대 법조단지 인프라를 바탕으로 아태 사법정의 허브를 법률 문화 교류가 활발히 이루어지는 국제법률 중심지로 조성하고자 합니다. 서초 법조단지에는 대법원 등 4개의 법원, 대검찰청 등 3개의 검찰청, 경찰서, 대한변호사협회와 670여 개의 법률사무소가 밀집해 있습니다. 또한 서울시 전체 변호사의 39%에 해당하는 약 9천 명의 변호사가 활동 중인 대한민국 최대 법조 클러스터입니다. 이처럼 최고 법률기관을 포함한 여러 기관이 밀집한 사례는 세계적으로도 유일무이한 사례로서 이러한 인프라는 아태 사법정의 허브가 국제법률 관련 회의와 기구를 유치할 수 있는 강력한 기반이 될 것입니다. 서초구는 2024년 대한민국 최초의 AI 특구로 지정되었으며 실리콘밸리에 버금가는 글로벌 AI 산업 허브로 성장할 예정입니다. 이러한 AI 인프라를 바탕으로 법조계, 스타트업, 학계가 협력한다면 디지털 사법 시스템 혁신을 이끌어갈 수 있을 것입니다. 또한 AI, 빅데이터, 클라우드와 같은 신기술을 활용해 국제 리글테크 산업의 중심지로 성장할 잠재력이 매우 큽니다. 서초구는 교통과 쇼핑이 편리하고 한강을 품고 있는 관광명소로 외국인 방문객이 많습니다. 여러분이 있는 여기 세비섬도 영화 어벤져스 2의 배경으로 등장한 바가 있습니다. 최근 서초구는 고터 세빛 관광특구로 지정되었는데요. 이와 연계한다면 법률, 관광, 문화를 융합한 마이스 산업 발전이 기대됩니다. 법조단지 옆에는 대형 규모의 서리풀 복합 문화 공간이 조성되고 있습니다. 2028년까지 760석 규모의 국제회의장과 대형 공연장이 포함된 서리풀 사운드와 스위스의 세계적인 회사인 헤르조그 앤 드메롱사에서 설계한 보이는 수장고가 건립될 예정입니다. 여기에 입주할 업무 상업시설과 인근의 풍부한 녹지 공간, 법조단지의 전문성까지 더해진다면 향후 국제법률 문화의 거점이자 국제법률 클러스터로 자리 잡을 잠재력이 충분합니다. 아태사법정의협의는 크게 3단계의 마스터 플랜에 따라 추진 중입니다. 1단계 법조단지 구성원, 관계자, 주민과 공감대를 형성하는 단계. 2단계 상징적인 특화 공간을 조성하고 본격적으로 사업을 추진하는 단계. 3단계 최종적으로 국제법률 문화도시로 도약하는 단계입니다. 지금부터는 이 마스터 플랜에 따라 지금까지 어떻게 추진되어 왔는지 말씀드리겠습니다. 2023년은 사업 준비의 해로서 입지 여건과 국외 사례 분석, 설문조사를 통해 단계별 세부 전략 수립을 위한 학술 연구 용역을 수행했습니다. 또한 법조기관, 변호사, 교수 등 관계 전문가로 구성된 자문위원회를 통해 다양한 의견을 수렴하고 협력 체계를 구축했습니다. 연말에는 첫 번째 학술 대회를 개최해 아태 사법정의 허브 사업의 가치와 미래에 대해 논의했습니다. 이를 통해 컨셉 있는 공간 조성, 친근하게 법을 접할 수 있는 프로그램 필요, 전문가 법률 교류 프로그램 추진이라는 큰 방향과 개념을 확립했습니다. 2024년은 본격적인 사업 출발의 해였습니다. 특화 공간 조성을 위해 법조단지 경관 개성에 대한 공청회를 개최하고 아시아 태평양 지역의 법률 허브로 조성하는 선포식을 가졌습니다. 공청회에서 수렴된 의견을 바탕으로 900년 된 향나무 상징화를 추진하여 공식 BI 디자인을 개발했습니다. 또한 법률을 친근한 문화로 느낄 수 있도록 법률기관 견학 프로그램, 버스킹 공연 등 다양한 사법문화 프로그램을 추진했습니다. 두 번째 학술대회에서는 국제법률기구 유치를 위한 한국 정부 및 지자체의 역할과 실행 방안을 논의했습니다. 2025년은 아태 사법정의 허브가 국제적으로 부상하는 해입니다. 법률 접근성과 국제법률 도시로의 위상 강화가 조화를 이루며 발전할 수 있도록 추진하고 있는데요. 상징물인 향나무를 중심으로 한 상징 공간을 조성하고 있으며 휴식도 취하고 회의 등 업무도 가능한 라운지를 조성해 주민을 대상으로 생활 법률 강좌도 운영 중에 있습니다. 또한 한국 법무부와 협력하여 오늘 HCCH 아태주간 행사와 같은 국제 법률 행사를 본격적으로 개최하기 시작했으며 향후 각종 국제 법률 관련 회의 개최도 지속해서 적극 지원할 계획입니다. 그렇다면 아태 사법정의 허브의 미래는 어떠할까요? 앞서 말씀드린 대로 대형 국제회의가 가능한 서리풀 사운드가 건립될 예정으로 이곳에서 다양한 국제 법률 교류 프로그램이 더욱 활발히 열릴 것입니다. 장기적으로는 국제상설 중재재판소 지역사무소 유치뿐만 아니라 아시아 인권재판소 설립 등 국제사법기구 기반 조성을 위해 국내외 관련 기관과 지속적으로 협력하며 전략적 파트너십을 구축해 나갈 계획입니다. 자, 그럼 여기서 대한민국 국제 법조계 인사의 아태 사법정의 허브에 대한 인터뷰를 잠시 들어보도록 하겠습니다.
제가 국제형사재판소 초대 재판관으로 헤이그에서 임기를 시작했을 때 2003년인데 헤이그 시장이 그 도시를 정의와 평화의 도시로 소개했던 말이 아주 인상이 깊었습니다. 헤이그는 단순한 각종 국제기구의 소재지를 넘어서서 정의라는 가치를 도시 정체성으로 만든 상징적인 사례였습니다. 서초구도 대법원, 대검찰청 등 주요 사법기관이 밀집한 국내 최대 법조단지로서 우수한 인프라와 높은 전문성을 갖추고 있습니다. 앞으로 각종 국제사법기구, 지역사무소 등의 유치를 통해서 서초는 아태 지역의 실질적인 사법정의 허브로 도약할 수 있을 것입니다. 또한 주민 친화적 법률 프로그램과 국제 컨퍼런스를 확대해 나가며 정의를 도시의 핵심 가치로 삼는 글로벌 법률 교류 중심지로 발전해 나가리라고 확신합니다.
Socho is an ideal city for hosting international organizations and conferences. Socho is home to key judicial institutions such as Supreme Court, supported by excellent infrastructure and a strong legal network. Socho's global appeal, natural beauty, and rich cultural assets also make it highly attractive for international events. As an advisor, I've witnessed Socho's dedicated efforts and achievement in becoming an international legal center. Through close collaboration with relevant governmental agencies, I firmly believe Socho can establish as the judicial justice hub of Asia-Pacific region and as a central platform for global legal cooperation.
지금까지 법률과 문화가 어우러지는 공간이자 국제 법률 교류의 중심지로 발전하고자 하는 아태 사법정의 허브의 비전을 말씀드렸습니다. 야심찬 비전을 품고 시동을 건 아태 사법정의 허브는 아시아 태평양의 헤이그를 꿈꾸며 한 걸음씩 나아가고 있습니다. 이러한 꿈과 비전을 실현하기 위해 저희는 앞으로도 국내외 법조계와 적극 교류하며 최선을 다하겠습니다. 이 자리에 계신 국제 법조인 여러분의 적극적인 관심과 지지를 부탁드립니다. 감사합니다.
Thank you, Mr. Mayor, for such informative contribution. We'd also like to take this moment to sincerely thank Mr. Mayor once again for his generous support and thoughtful involvement in helping make this event a success. We have now reached the closing ceremony of HCCH Asia Pacific Week Seoul 2025. It is our pleasure to invite Dr. Christophe Bernasconi, Secretary General of the HCCH, to deliver the closing remarks.
Excellencies, distinguished participants, dear friends, all good things must come to an end, and so must Asia Pacific Week 2025. It is now my distinct honor to offer a few words as we bring this remarkable, enjoyable, and enriching edition of the Asia Pacific Week to a close. Once again, we have seen just how powerful it is when diverse voices from across the region and beyond come together, not only to exchanging ideas, but to build bridges, strengthen collaboration, and breathe life into our shared commitment to the work of the HCCH. This year's edition has once again highlighted the vitality of this broad and dynamic region, as well as the continued relevance of both our existing HCCH conventions and our current legislative projects. It has been a real pleasure to return to Seoul following the successful 2017 edition of the Asia Pacific Week. The spirit we found then of openness, curiosity, and genuine collaboration was very much alive this week as well. My heartfelt thanks go to the Republic of Korea for hosting us once again with such warmth and generosity. You really have taken excellent care of us. Thank you all so much for your gracious hospitality. I would particularly like to thank the joint organizers of this year's event, the Ministry of Justice, the Korea Association of Private International Law, the Judicial Policy Research Institute, the Ministry of Health and Welfare, the Korea Institute of Criminology and Justice, the National Center for the Rights of the Child, the Socho District Office, and may I take this opportunity, Mr. Mayor, to congratulate you wholeheartedly on these very impressive plans to turn your district into the Asia-Pacific Justice Hub. But I would also like to extend my warm thanks to all the staff who have supported us over the past few days, including the MCs, the technicians, and interpreters. To all our speakers, moderators, and panelists, your thoughtful insights and informative contributions have truly been the lifeblood of this week's discussions. It is thanks to your expertise, engagement, and generosity in sharing your perspectives that this event has been as stimulating and enriching as it was. This edition of Asia Pacific Week has once again shown that the HCCH is not merely a collection of conventions and instruments. It is, first and foremost, a true community of dedicated experts and professionals. A community committed both to developing meaningful, practical tools that make a real difference in people's lives and to ensuring that those instruments work effectively in practice across borders and legal traditions. That spirit of inclusiveness and shared purpose and the camaraderie that comes with it is ultimately the real value and lasting strength of the HCCH. Looking ahead, I'm hopeful that the connections forged here and those rekindled will continue to deepen. And yes, I'm hopeful that we will reconvene next year for Asia Pacific Week 2026. Having spoken to some of you, I understand that there may indeed be an opportunity to continue this wonderful and meaningful tradition. Our Korean friends have certainly set the bar very high, but I have no doubt that the next edition of the Asia Pacific Week will carry the same spirit, the same drive, and the same fruitful exchanges. And who knows, we may even find ourselves marking an anniversary, one traditionally associated with wood, symbolizing the strength and resilience of the relationship. A fitting occasion, perhaps, to celebrate how firmly our roots are taking hold in the region. Now, I have you all wondering and curious. Good so. And on that happy note, I say thank you very much and goodbye.
Thank you, Mr. Secretary General, for your thoughtful closing message and your continued leadership throughout this symposium. On behalf of the Ministry of Justice of the Republic of Korea, I would like to show our extreme gratitude to all speakers, panelists, and moderators and attendees, both here in person and online, for making this event such a success. Lunch will be served shortly, and we invite you all to join us in continuing the conversation in a more relaxed setting. Before that, we would like to invite everyone present to join us on stage for a commemorative group photo. Everyone, please make your way to the stage so we can capture this special moment together. 장내에 계신 모든 분들은 기념사진 촬영을 위해 무대 위로 올라와 주시길 바랍니다.